the Law and Licensing Committee, in accordance with our bylaws, this session is being held here at USB, but also being broadcast via the internet. Our chair, Matt Hymas, is online, and I'll just, Matt, are you there?
Yes, I'm here. Thank you,
Matt.
Vice Chair Carey.
Okay, and Board Member Hart is here as well. She just stepped out. But just in light of the agenda and the many items we have, I'd just like to start. Then let's go to item 3.2, Interagency Data Sharing Agreement with Department of Workforce Services. And I think that's Director Chalice.
Good morning, committee. I'll start by saying we have some folks online for this item, 2 individuals from DWS and I believe several staff members from USB staff members from Child Nutrition Program. So just wanted to preface that so that if you have any questions beyond privacy questions, they'll be available to answer those. All right, so I'll queue up the item. This is a data sharing agreement between the Department of Workforce Services and USBE to facilitate the sharing of information for students who are currently eligible for free or reduced lunch programs. I'm going to oversimplify this a little bit. To help DWS determine if those same students are, to help them determine who is eligible for the summer EBT program, which is a food assistance program for the summer, to kind of fill that gap of students who are relying on food from school during the school year. I will note that this agreement, an almost identical version of this agreement, was passed by the board in, I believe, February. It's coming back to you because the legislature made a decision not to fund it for the 2024 summer. And so we started the process over again. We're bringing it back to you, but I just thought that might help you understand kind of the context that this was already approved earlier this year. And that concludes my introduction, Chair.
Thank you. Any questions? Let's just go down the line. Board Member Lear and then Board Member Wood.
If it's not going to be funded, how is it going to take place?
Thank you, Chair. Would you like me to answer?
Through the chair.
The 2024 year was not funded, but the expectation is, and I'll let Kimberly speak to this if she has clarifying language, but that it will be funded ongoing. It was if they decided not to fund it for 2024, but they will be funding it going forward. So this agreement is going to prepare DWS for data sharing that will occur next summer.
Okay, and by they, you mean the legislature?
That's my understanding. It's a funding match that's conducted through federal funds and the legislative and Utah, I think. And Kimberly, feel free to correct me if I'm wrong.
Okay, thank you. That was my question, but something you said triggered. I recently received an email that said that there were changes made, and maybe this is to those of us online, that are going to prevent any fees from being charged for our low income. It was by USDA. Does this change anything? Is anyone aware of those changes that occurred just recently?
That's probably best for Kimberly to speak to.
Good morning. USDA recently released a memo regarding charging online fees when households pay for school meals for students that qualify for free reduced price meals. And that doesn't come into effect till school year 28, but that is a separate policy in regards to the summer EBT program.
Oh, thank you for clarification. It was the online fees. That's much clearer. Thank you.
So I just have just a few questions on page 8. And I think we covered most of these already, Director Chalice, but that last line, it says, this is also true. Well, are you there? I don't want to.
Just a sec.
It's the attachment B, scope of data sharing. Oh, yes. And then down, this says page 8. Maybe we went too far. Yeah, right there. It says, last sentence, this is also true for information obtained through summer EBT applications per regulations. That's the wrong sentence. It says right before that, this means that free and reduced price school meal application data may be shared with summer EBT agencies. What are those agencies? Are those public agencies or are those private nonprofits? Who are those agencies?
Sure. This language is other state, depending on the state, they're going to be the agency initiating or facilitating this program is going to be different. This language, as I understand it, came from guidance from the the National School Lunch Act program federally. And so they were saying maybe shared with summer EBT agencies describing to the country how to act. But in Utah, it will be limited, as I understand, to just DWS because they are the agency that facilitates the program. So that's a long way to say only DWS.
Okay, then that was my understanding. I just wanted to make sure.
Yeah.
And then if we scroll down to page 9, and again, we discussed this. I just want to make sure the public understands how, right there, Ben, thank you. We do take student privacy very seriously, and it's my understanding that all of these items listed under data and other information requested, that all of that information is absolutely necessary in order to identify these students. There's nothing gratuitous on that list. Is that correct?
Yes, that's correct. We had extensive discussions with DWS to make sure that we were minimizing the data to only what was necessary for them to determine eligibility.
Okay. And then the last question on page 10. On the signature line, right above it, it says, additionally, authorized individuals at DWS will be assigned time-limited accounts to USBE's SSID lookup tool and data gateway. Can you explain why that is necessary?
You bet. So this agreement is, I would say, primarily for the purpose of sharing information that USBE houses about students who are already eligible for free or reduced lunch. But there is a secondary purpose to this agreement. I would argue a smaller piece of it, which is that DWS has the ability to accept applications for folks who apply who maybe weren't eligible during the school year. And they asked for this ability to look up information so that they can confirm what the enrollment of students who applied separately from the eligibility that we already shared with them. So it's a need. We established this lookup feature so that it wasn't a big bulk dump of data, but rather gives them ability to do address checks and whatnot. And I invite DWS to correct me if I'm mistaken on that.
Katie, you are not mistaken. However, it's not just a need, it's a requirement by federal statute that we, as the state agency that's coordinating the program, allow submission by parents through the summer period of operation to apply for the program with us. And this would include access for any student that attends a CEP or provision school, because you do not collect free and reduced meal data at those schools. So we have to apply an ability for those households to apply, and that's the purpose of this particular section.
And just to make sure, Director Chalice, the same privacy protocols that we have in place for the bigger part of this request would also apply to this direct access they would have.
Yeah, that's correct. Thank you.
Any other questions from the board? If not, we're ready for a motion.
Oh, just my light's on. No, I didn't. I'm sorry. I just have a comment.
Oh.
I just wanted to thank Kimberly for she followed up on some questions that I had, and they were very detailed and helpful. And thank you for following through on our request for the opt-outs, like that we give parents that ability throughout to I don't want the data shared. I don't want to be involved in this program. So thank you for that additional work that was done based on our request, probably back in February. So.
Okay, we're ready for a motion.
Okay, I move that the committee approve the interagency data sharing agreement with the Department of Workforce Services number USBE 2500-12IAA and forward to the board for approval.
Okay, the motion before the committee is that the committee approve the interagency data sharing agreement with the Department of Workforce Services, number USBE 25001-2IAA, and forward to the board for approval. All in favor?
Aye.
Aye.
Okay, that is unanimous. Next item is item 3.3, Uinta River High School waiver request. And Ashley Beal?
Yes,
Oh, she's online?
I
Oh,
am.
Ashley, good morning.
Good morning.
Do you want to cue this up for the committee?
Yeah, absolutely. So this is a waiver request from Uinta River High School that they filed under R277-121 for a waiver of Rule R277-419-4, which requires a minimum of 180 days of attendance. Uinta River High School is kind of in a unique situation. They're a charter school. And they operate under partial funding and governance by the Ute Indian tribe. And the tribe actually maintains a 4-day work week. And some of the school is reliant on basically the tribal transportation to get the kids to school. So they're kind of in a unique situation where they're actually reliant on that transportation for school. And the work week is 4-day work week out there at the tribe. So their board approved the request on August 22nd, 2023, and then they sent it to the State Charter School Board. And due to a mix-up and some change in staffing at the State Charter School Board, we didn't get the signed letter from State Charter School Board approving that request until last month. So we just got it on our agenda now. But yeah, the school's been, I think, actually operating on the schedule for a little while now because they thought it was a part of their charter, and we figured out that it wasn't. And so we're just kind of trying to correct that now.
Thank you. And it's also my understanding that we have in person the principal for Uinta River High School, Alejandro Vasquez. Is that correct?
No, I'm the admin assistant. Principal couldn't be in person today. She should be on Zoom call, I believe, though.
And that would be Brittany Luck?
Yeah, that would be Brittany Luck.
Okay. Well, okay.
And
could you just state your name for?
Alejandro Vasquez.
Okay. And Alejandro, it's your time. Is there anything you would like to add to that?
We also do with our tribal members work. Most of our students, their parents are tribal members. They do typically work for the tribe. So a lot of them live quite far out and are low income housing. So a lot of them don't really find the time to come down to town when it comes to Fridays, or they don't need to exactly. And since a lot of them are working for the tribe, they like to maintain that tribal schedule for them. We've sent out surveys to these parents. So the replies we got, they would rather maintain that 4-day week. We as well offer Friday school option for students where they have the option to come in from 10 to 3 to work on any kind of makeup work that they need to get done and everything like that. We do with our schedule as it is, we do about 150 days from about our doors open at 8 and we're there till about 4:30. With those hours, we do go up over the state minimum by 87 hours.
Any questions from the committee?
Just a comment.
Board Member Wood?
Yeah, I really appreciated the description of your Friday initiatives. It looks like you really are giving options to students that need them. But then it was interesting listening, I guess it's an and, not a but, listening to the parent feedback that they said it's really motivating for kids to get their work done in those 4 days so they don't have to do anything with the Friday program. So appreciate the work that's being done there to both motivate and to support families.
Thank you.
Any other questions, comments from the board? If not, we'll entertain a motion.
I move that the committee approve Uinta River High School's request for a waiver from R277-419-4 and forward to the board for approval.
The motion before the committee is that the committee approve Uinta River High School's request for a waiver from R277-4194 and forward to the board for approval. All those in favor? Chair Hymas? Oh, okay. Then that is okay. It's unanimous decision. Thank you very much. Okay, let's move to item 3.4, R277-114, response to compliance and related issues. This is an amendment. And Director Rasmussen.
Thank you, Chair. Ben Rasmussen, Director of Law and Professional Practices. The committee may remember that this rule came up for discussion in October, and there was some considerable discussion as to prior amendments that were proposed. Essentially, the concern here is that the staff wants to have some language in the rule that makes it clear that federal programs are treated a little differently when it comes to oversight. And so based on the feedback that came from the committee, a different proposal is coming forward, and that's what you see in draft 2. The language there, the sole change would be on lines 21 through 23, or 20 through 23. Aside from the oversight category being added, the proposal is just to add some language just at the start of the rule that says that the rule, except for the section on appeals, does not apply to oversight of federal programs. In the case of federal programs, there are generally going to be federal regulations that outline what the monitoring should look like and what that program should look like and what the requirements are. And so with this change, it would just make it clear that in those cases, we're going to turn to the federal requirements.
Any questions? I have one question, and that's on lines 55 through 57. And one of the amendments that was made when this rule went through was that we had a reporting structure added that said before board leadership works informally with an oversight entity, as described in subsection 3A, board leadership shall notify the board member or members who represent the area where the oversight entity is located. Director Rasmussen, are you aware of how many times such notice was provided to a board member as required by that provision since this rule's been effectuated or enacted?
I am not. This was a rule that the Deputy Superintendent Stallings had been working on, and so I have not gotten a lot into the weeds about the different requirements there. And I don't have an answer to that question, no.
I'm just going to ask, and if you could just before this comes before the full committee, I just want to see how often we're using it, how effective it is, and I think that metric would help us measure that. Okay. And if you are able to track that down, if you could just provide it to all the members of the committee.
I will follow up on that.
If there are no other questions or comments, we are ready for a motion.
Motion on the screen for you.
I move that the committee approve R277-114 response to compliance and related issues draft 2 on first reading and forward to the board for approval on second and final reading.
The motion before the board is that the committee approve R277-114 response to compliance and related issues draft 2 on first reading and forward to the board for approval on second and final reading. All those in favor? Any opposed? That motion passes unanimously. The next item is R277-123, process for members of the public to report violations of statute and board rule, amendment, and Director Rasmussen.
Okay, thank you, Chair. So there was some, this as a reminder, is another rule that's coming back to the committee from the October committee discussion. The attempt in the amendments in this rule is to further clarify how the audit hotline process is handled, both by USBE and also to elaborate what requirements are made of LEAs for their audit hotlines. After the feedback that the committee gave last month, staff consulted the audit committee, is my understanding, and also had some discussions and came up with two new draft options. So there you have draft 2 and 3 that are in your backup. Draft 2 holds to the same general approach as the prior draft does, but adds some clarifications to different things based on feedback. Draft 3 is a more significant change from the prior draft in that it restores the provision that allows LEAs to defer to USB for their hotlines and takes out a lot of provisions the LEAs objected to as far as adding to their policies and things like that. I think you'd probably want to invite Chief Audit Executive Davis up if she wants to elaborate more on the thinking between these two drafts, but essentially staff has tried to provide the committee with two options to look at and discuss today, and then we can go from there.
Sure.
Thank you, Amber. Okay, now I'm on. So Chief Audit Executive Debbie Davis. Thank you for the opportunity to provide a little bit more insight to the drafts that were prepared. We took very seriously the feedback that was provided in October, considered it carefully. There are two drafts because one, we wanted to make sure we know how important local control is to the board, and draft 2 seems to preserve the most local control with LEAs having their own hotline. So that's why we preserved draft 2 with cleanup, as was talked about in the prior meeting. Then we took draft 2, and because there was also to consider the feedback that, hey, it would be, we would appreciate the ability to continue to use the state public education hotline. We wanted to, okay, we'll move down the spectrum from local control to give the state a little bit more, I guess, control, because things will come into the hotline once the state knows. We might be a mandatory reporter if it's related to something with DCFS or something. So it preserves the option to use the state public education hotline. We did strip out a lot of the other provisions. Again, just moving along the spectrum from local control to more state control. I think it prudent to point out that the public education hotline for the state, public education is complex and big and vast. And so the concerns that we receive are not just related to local education agencies. They might be related to the State Board of Education or authorizers or contractors, those types of things. So there needs to be space within that rule to consider concerns that are not related to LEAs. And I know that's come up with, there's concerns with, oh, you have this other concern in there. That's one of the reasons why we have other concern. Also in that regard, we can't control what comes in on the hotline. People will report what they report. Sometimes the things that come in, there are multiple concerns. Some of them might be alleged violations of board rule or Utah code, but other things are these other concerns and they might be mixed up. So maybe that provides a little bit of context to the concern about the use of the term other concerns. But again, we feel like there's a spectrum in this space of who's going to look at concerns that are being reported. And I think the board has a challenge in figuring out what is the balance to consider both the individual that's making the report and the entity about which the concern is, and how do you balance that and provide adequate due process and accountability on both sides. So this definitely is a tricky space. And again, I just say you've got local control, you've got kind of a hybrid in the middle of that spectrum. And then we've seen the legislature, if they perceive perhaps that public education is not taking care of this, right? Like an ombudsman has come up, or we've seen with Medicaid, they instituted an Office of Inspector General and they just handle it there and it's taken out of our hands. We've seen in public education precedent for this with data reliability, where we have the Office of the State Auditor and even Legislative Auditor's Office. They perceive that we're not providing readily, easily accessible data. So they're now trying to do that for us. So a lot of different things to consider in this space. Draft 2, ultimate local control. Draft 3, preserve the status quo with that option, but a lot of cleanup has been done, and we did try and take all the feedback that was provided in consideration of the amendments that we provided.
Thank you, Chief Audit Executive Davis. Let me just say this, because typically when we get drafts, we deal with one draft, and right, it's the latest one. This one, there's actually 2 on the table. So I would just ask, if we're addressing a particular draft, that we just state what that is, just to minimize confusion. Board Member Lear?
And I appreciate the work that was done trying to take our feedback. I'm realizing that, at least on my part, maybe the feedback wasn't as clear or as significant as I wish I'd been. And I tried yesterday to come up with another draft that was more what I was thinking, and just didn't have the bandwidth. Sorry. Ben tried gamely to read my writing, but it didn't translate well. So I only can provide I can only provide some general comments today, and then I have a couple of options that I've been thinking about that I would like to see what the committee thinks about. I don't really have one that I'm settled on, but here are my 2 concerns that are still not addressed. And I am looking at draft 3, but I don't believe that they're addressed. And I didn't have time to carefully read draft 2, but I believe they're not addressed adequately there. First of all, I have heard from a number of LEAs, very small ones and bigger ones, that this is overreach. They feel this is overreach. And I hear what you're saying, Director Davis, about the concerns, the could be, should be's, other people, other entities taking over our role if we don't do something. I hear you, but I am more persuaded by the LEAs I've heard from who say this is overreach, this is micromanaging, we don't need this on top of everything else. And I agree with that. So that's one of my concerns. My second, maybe more serious concern is that there is a lot of language in here that strikes fear in my heart, frankly, because you can get a hotline complaint that could be very damaging to someone's reputation, just in a statement. And I actually, as I was thinking about this last night, I had this experience when I was working with the school district. And I can give you more detail if you want, because I don't want people to say, oh, that'll never happen. People don't ever do that. I saw a very similar kind of situation working with the school district. And it took 4 or 5 years until literally the students of some very vindictive parents aged out of that school for the school district to try to rehabilitate a couple of administrators' reputations. But here's the language, and this is just an example. It's in a couple of other places. I'm looking on line 161 in draft 3. The IAD may also send the referral to other school and district employees, including the superintendent, business administrator, hotline specialist, and others. If something is said on a hotline complaint, it could ruin a person's career, and to distribute it like that is just not responsible in my mind. You could probably remedy this, or possibly remedy it, with very strict language about confidentiality, although I'm not really convinced that would work. So I guess what I'm trying to say is I'm not satisfied with this as it's written, though everyone has tried hard. I think we were caught up in some staff changes, some at the USBE, and a number of other things that made it hard to at least for me to communicate what I was thinking. So my 2 thoughts are, and if the committee members want to respond, that'd be great, or not. But I would either prefer that we have no rule at all and we leave it the way it is, and we try to support Director Davis's staff better, or Director Davis better with the staff that can then follow up on the hotline complaints more, because I think part of this grew out of the fact that you feeling like this was, and I am talking to Director Davis, if that's okay. With you feeling like the staff was sort of being eaten alive by complaints when you referred most of them back to the LEAs anyway. So why not have them go directly to the LEAs? So one thought would be to support Director Davis with the staff she needs, or reassign or along those lines. The other possibility is to, that I've thought of, is that we allow the LEAs to still use either have their own hotline or use still use the hotline that comes to the state. So those were my thoughts, but I'm just almost appalled, and it's no one's fault. I'm not blaming. I just can't have a hotline complaint that is completely unsubstantiated go out to numbers of people in numbers of places and affect people's careers. So that's my rant. And I just would appreciate anyone's thoughts on that.
Board Member Hart?
Yeah, so part of this came to audit because there were a couple of districts upset that a complaint had come in about their district and they were working on resolving it and they didn't want us involved. So I don't know how to reconcile the fact that they don't want us involved, but they don't want to have a hotline either. That it's incongruent. I don't think there's ever any removing of the hotline or not taking a complaint, was there? We still take any complaint that, Chair?
We take every complaint we receive, we log, and we handle it in accordance with our process or policy. And to Member Lear's point, our policy is we refer to 2 board members. Usually it's the board president and the vice chair or the audit committee chair and the superintendent, because LEAs have told us, like, hey, we really want the superintendent to receive the concern. So that's who we normally send it to. If there's an occasion where the business administrator should receive it, if it's financially related, we might send it to them. It would be extremely rare that we're sending it to anyone else, but because, and this is trying to answer the question of how do we refer back and who do we refer it to for accountability, because we can't keep tabs on every lower level LEA employee. How do we refer? What does that look like? And wanting to make sure for LEAs that the superintendent will get it unless they're implicated. So that's the intent of lines 161 through 163. And now I've over answered your question.
I don't know. There's got to be a way to arrange this so I'm not stretching my arm. I don't know why it has to, the lines 161 through, and I hear both what you're saying and what Molly's saying. But there's got to be a way that stresses confidentiality, because you make it sound like we only do this, but the lines that we are talking about read much more broadly than that. And then there are other places where it says, or anyone else we think might have information. And that's just not acceptable to me. I think it's scary to me that because some of the situations that come through on hotlines are damning on their face. And I can't have those. And I've seen vindictive people. So it's not just paranoia. So I think there's got to be a way to resolve that or moderate that. And I don't know. I also think that Molly makes a very good point. And maybe it's up to the board to choose between saying, perhaps the LEA is not solving it in our view in the way that it should be resolved, but it is addressing it, and we're going to have to let go of that control and let the LEA do it with the consequences that come with that. So appreciate your responses. I just think that there's got to be a way that doesn't micromanage LEAs. The whole language about, I don't even like the language about shall be referred to 2 LEA employees. I think the superintendent is the executive for an LEA. And that's who we should refer a complaint to. And if the board members or the complainant or somebody doesn't think and I agree, unless the superintendent is the object of concern. But I don't believe that complainants should tell us, we don't like you sending it to the executive for the LEA. Then do something about your executive. So those are my concerns. I've more than explained. I've outdone Debbie.
Vice Chair Hart.
Yeah, so I've been the recipient of, in my day job, of complaints that come to the audit hotline. And there are cases when it's something I knew about, and unfortunately somebody just didn't like an answer. So they appeal to a higher power, and they're hoping for a different outcome. There are other times when I know individuals have tried to make an audit. They've tried to resolve it at a local level. They don't know who to call. They're larger organizations. They try to resolve it at the principal level. It doesn't work. They try to go up the chain, but the chain is not clear in some of these large districts. So you can call a director who tells you to call it's a curriculum issue. So then they send you over to curriculum, and then curriculum says, well, that was, decided actually in responsive services. And so by the time that a person finds in some of our larger districts, the person that actually they need to talk to, they're pretty frustrated. We already have hotlines required. We have an audit or a fraud hotline that is required in every district. This requires nothing more than having even that same number listed on the website that says, call here to start your search for an answer. And the person that answers that phone knows where to send the call. This is not asking people to hire a person that sits next to a red phone and waits for it to call. It's simply asking districts to make it easy for constituents to get to the right place, so that they don't call up to the state and all we do is turn around and call the superintendent. And that's ping-ponging people. And every time they get ping-ponged, they're not getting an answer. And then to have people come back and say, why did you get involved in this? Well, this is not the deal that it's made out to be. It's asking LEAs to take local control and we've identified an issue, and there's an easy way to solve it. Now, in my day job, I am a tiny LEA. I still want these concerns. These don't come in, 3 each week. This is very, this is not that common. And generally, what the issue is, and you've tried to deal with it. So it's good that there is another place to call. So what I'm saying is I would never say one or the other, but I am saying that it's absolutely appropriate that we take what we've done in the fraud space and apply it to general concerns that a constituent would have, so that we eliminate a middleman. Now, I agree, we could take out others, we could narrow that down. If we do, I think that special education administrator might be something that because that's a large group of concerns. But we could limit it to the superintendent and the business administrator too, if we wanted to do that. That's not as much the issue as much it is asking our LEAs to except address the need that would possibly get a constituent an answer quicker. That's all.
I think you have a motion if you have a motion. Yeah. I think sure.
So, Chief Audit Executive Davis, I just have to say thank you, because when I thought about this, you had like 5 chefs in a kitchen, and some are saying bake, a vanilla cake. Some are saying bake a chocolate cake. Some are saying we want frosting. The others are saying we don't want frosting. We want fruit. We don't want fruit. And you were the baker. And that was a very, very difficult task to navigate. And I think that's why we see the 2 rules. Yesterday in our executive session, there was discussion about how can we better support, just generally our staff. And then I thought about this, and I'm thinking to myself, I don't know if we really did a good job with this, because all we did was say, bake these cakes. And that was possibly unfair. So I want to thank you and commend you for the work you did. So I just want to say that I have concerns about both drafts. I told Vice Chair Hart, I call this the rule of 9 cat lives, because everybody, from LEAs to charter schools last month had reservations about it. All the committee members had reservations about it. And I thought we won't see this for, another 4 months. But due to the efficiency of your team, it's back. And so, and not only one version, now there's 2 versions. So, but I did want to say thank you. I mean, you were really given a mission impossible, and you did your absolute best with your staff, and thank you for that. But if there's no other comments, then we will entertain a motion.
Okay, well, shoot, and I had one other thing that slipped out of my head just now. In addition to saying, yes, thank you, it was a really hard task. And I feel like personally, I didn't communicate what I meant to communicate adequately to you. I would like to propose that we try one more stab at this. And I think the staff has stabilized a little bit now, and that'll help us. And I'm committed to try and communicate what I think is important about this, because Leanne just made a very good point to me privately, that she's looking at it from a parent perspective. I'm looking at it more of former legal counsel for many LEAs who were not being secretive, not being and all deceptive at all. Instead they were trying to work through problems the way bureaucracies work through problems, and it isn't quick. And Leanne's looking at it like a parent is frustrated. And I get that there are 2 competing forces that are really important. So I'd like to try one more time. And maybe here's my thought, that this is more to Molly. Maybe it is a training issue, because the LEAs I talked to did not process it the way you did, in terms of combine it with another hotline, combine it with another complaint process. You can make this, it's not this hard. So maybe it is more of a training issue, or that's another factor. So I'd like, with all of that explanation, explaining my motion before I make it, I would like to propose that we try one more time to come up with something that is responsive to parents who have concerns, but is also protective of people in their jobs and their reputations. And it stresses one of the big issues in the both the new and then the revised sexual harassment regulations was just every step of the way they stressed confidentiality. And you can hate them or love them, but that confidentiality piece of it is really, really crucial when people's jobs are at stake.
Just for clarification, I don't mean this facetiously. I really don't. I hope.
I would never take it that way.
Well, so wait till I ask it. How is it less confidential to go directly to the LEA, to have to direct parents and make sure parents can get to the LEA, how is that less confidential than sending it up to the state, which is outside the LEA, and then back down, knowing that depending on what kind of, and you absolutely right, some of these can get pretty wild and include all kinds of
Unsubstantiated,
completely so why, how is it, so if a child's safety is at risk, we're mandated reporters, we now have to make a DCFS referral. If it's harassment, we've got all those. How is it less confidential to send it directly to the LEA rather than up to the state and all the mandated people and then back down to the LEA?
Well, and if you're asking me, I'm not saying it's less or more confidential. My point is the way that this is written, it just screams notifying a bunch of people that I don't think need to know.
Okay.
At least at this stage, this is an allegation.
So
for
when
Pete's
it,
sakes.
so your problem, well, so what you're addressing there, just because I have a feeling we'll all see this, what you're talking about is kind of a separate thing. You're not at that concern isn't the fact of a LEA hotline versus a state.
No.
It's when the state gets one.
Right. It's
Okay.
that's my, although you could be right, you could be wrong. I just feel like if an LEA, and I have a little bit of a wash your hands of this. I don't want our agency to be responsible for dispersing with all of our expertise and concern about privacy. I don't want our agency to be dispersing information with, even though they're adults now, maybe, but it could involve children. I don't want us to be responsible for that carelessness or just. I just don't want us to be responsible. If an LEA botches it, yeah, we need to increase or improve their training and help them. But at least it's the LEA. It's not our agency who's supposed to be the expert in privacy, data privacy, and this could all be implicated.
Okay.
So it's yes, whether it goes to the LEA directly or to the state, that's a different issue. That's the issue I heard about in terms of you're now asking us to do one more thing, another, and they did read it as a comprehensive hotline experience. So I think we can figure that one out. And I like the idea of leaving both the state hotline as an option or saying to LEAs, if you want more confidentiality, have your own policy and process.
And just as a note, the state charter board closed theirs down and we're getting all of their complaints as well. That has also happened in the last year, so the state charter board doesn't have their own at this point. So we're getting all those as well, which I would like to just remind the committee that we did put the audit FTEs into our priorities. So we do have, tried to address that too.
So anyway, so back to the point, let's try it one more time. Maybe we'll end up saying, no, there's not a satisfactory way to do this to address the concerns of parents, the concerns of reputation, the concerns of efficiency. And we're just going to have to hope that our audit requests for additional personnel get funded. Because I think those are all valid concerns. I cannot abide, having had a couple of experiences like this, I cannot abide putting allegations out there for multiple people to know about.
Let me just thank you for that exchange. It was very informative. And Chief Audit Executive Davis, that exchange raised a question in my mind. Are there certain allegations, even though they're just allegations, when they're reported to the USB hotline, that we are required to advance to the state? To any organization, but yes, most likely DCFS.
Yes. So if there is an allegation of child abuse and neglect, we are mandatory reporters and we must report that to DCFS. Actually, just this morning, we received a concern from DCFS. They wanted us to be aware, and we sent one to DCFS. So that is probably the number one report that we do. On occasion, we do send, if it's a licensing issue with like a residential treatment center, we might also send that to DHHS, Health and Human Services, because they license. And we want to make sure like they're going to handle that. We're not going to handle that. That's not so much mandatory as we just want to get the concern to the right person that can review it. And if action is needed, they could take it. So the child abuse and neglect with DCFS is probably our number one mandatory. We're going to send that somewhere. But on occasion, we do get other things that we would send to another state agency.
And my related question is, if that same complaint were made to the local LEA directly through their hotline, they would also be under the same requirement to report that. Is that correct?
That is correct.
But what we're doing is we're adding to that reporting requirement in some of these rules, because we're saying not only do you have to report it to the legal obligation, but there are these other entities we may also want you to share that information with.
There's nothing in 123 that is requiring an LEA to report to certain individuals. The mandated requirement to report to DCFS is in Utah code, not 123, right?
123 is they may.
As they may, right.
Okay.
So there's nothing that says, oh, if an LEA received a concern, I don't even know if this would happen, like about a residential treatment center or something, they'd have to send that to the, Health and Human Services or whatever. It's all left to their discretion and whatever their policy says about how they would manage that concern. So really there's a lot of discretion at the local level, how they would handle it. But then at the state level, of course, we have to handle things the way
Understood.
they should be.
That just because of time, here, excuse me, Board Member Lear, did you make that motion or you?
I would like to work on it again for another month. I didn't, oh, it's up there. I'm sorry. Can you do that control plus thing? That the committee postponed discussion of the, yeah, thank you. That's good enough. And direct update to be responsive to parent concerns and protect the confidentiality. And and other things, of course. I don't think anybody would read that to be limited, because I do think we've got to resolve what do we do with the hotline situation that doesn't overwhelm you, but allows for local autonomy. So we've got to figure that out too. So yes, that's satisfactory for my motion.
Board Member Wood.
Thank you. I would speak against the motion. I thought draft 3 took into account a lot of my concerns in terms of who it was being reported to and how that was kind of going around LEA. And I think there's a few tweaks that we could make in terms of the confidentiality. But yeah, I am thinking of it as a parent. I actually had some language added to draft 3 that requires the LEA to notify or to have notice on that if a parent is calling in, whether it's a local LEA number or if it's going directly to the hotline, so they're aware when they call in that they're not. That was lines 221, 223. I had that added in so that parents know exactly who they're calling, so that they're not confused. I actually like the "and concern." I know we had some feedback from the field regarding the other concern, but I think, as you say, parents don't know when they call in whether they're calling a hotline for fraud and waste or they just need somewhere to turn. And so the other concern allows that to be a single entity. So I think we've simplified that for our LEAs in terms of who they call into. And I think with a few tweaks that I have some suggestions, but it wasn't worth making if we're going to send it back. So that's just where I'm at.
Thank you, Board Member Wood. I would just speak in favor of the motion. I think draft 3 is very close to where I would like to be, but I do have several concerns about privacy and due process that I think need to be incorporated into this draft. Does anyone else have any other, would anyone else like to speak for or against the motion? when you really need a fifth.
I am good with draft 3. I think there are some small, not substantive changes that some technical changes. I feel like the problem is no, I'm not gonna. I'm just gonna vote, and then you're gonna figure it out because
Well, Chair Hymas?
he's not gonna save you.
Okay. Then
Yeah.
the motion before the committee is that the committee postpone discussion of the rule and direct staff to update draft 3 of the rule to be responsive to parent concerns and protect the confidentiality of individuals who are the subject of hotline complaints. Those in favor? Aye. Those opposed?
No.
Oh, the ayes have it? No.
So-
So that motion is a tie, and it's my understanding that if it's a tie, the motion fails. Okay. We'll entertain another motion.
I have a motion. Oh,
Go ahead. No.
I have a motion to amend lines. Let's see, when we go back 160, I think it's 160, 158 through 162. So I would like it to read, so it currently reads, when the IAD makes a referral to an LEA, the referral will be sent to at least 2 members of the local governing board and the superintendent. Does that align with the charter? Does it, you wouldn't have a superintendent?
Or direct.
Is it kind of like when we say superintendent is, so, okay.
I think you said superintendent.
It falls. Okay, thank you. And then the next line, sure, sorry. When the IAD makes a referral, to an LEA, the referral will be sent to at least 2 members of the local governing board and the superintendent. And then in 161, the LEA shall send the referral to other school and district employees as needed to further investigate or resolve the complaint. This puts it in the hands of the LEA to determine where the referral is going. They're going to best know. We could I don't know in terms of role writing language, if there's something about maintaining confidentiality, if that's an appropriate addition there. I'm happy to add that if in role writing language that's appropriate. That's my motion.
Let's ask a question to that.
Please.
Maker. Why do you need, are you saying we don't trust the superintendent? That's why you want to send it to 2 board members? Because the executive director is the superintendent. What's your point in sending it to 2 board members?
Please, thank you.
In my opinion, the board member is the elected member. That's who the people see as their voice in a school district as to who they return to. So
you don't trust the superintendent to get that message to the board members?
Oh, no, I'm just saying in a representative government, they know who to turn to as a locally, they elected those board members to be their voice. And so that's
me,
why. So it's not a
that's-
trust issue in any way. It's an ability of who would I go to if I have an issue? I'm going to go to the board member I elected.
I think it
That's-
speaks distrust, but. Okay.
Vice Chair Hart, did you have a question?
No,
Comment?
I, even though I happen to be a director in my other life, I do think it's appropriate to go to a board member because that is, because so many of these issues have to do with policy as much as I would love for it to just come to me and the board never even hear about it, I think it's appropriate to go to a board member because that's the elected representation for policy issues and governance. And so I just feel like it's appropriate. We've also had some incidents come up where it really did need to go to a board member. It just was, it made sense to the issue. I don't know how to describe that in a summary kind of way. But it was just, okay, cool.
I appreciate your, I've been trying, and I have to ask a process question.
Yep, point of information.
If we're gonna pursue this, then I've got a bunch of amendments too. So is it now a good time to do it on top of this, or do you want to vote on them one by one?
Well, since this motion is on the table, let's vote on this and then we can have a committee discussion as to the best way to proceed. Would that work?
Thank you.
Yep. And then I do have a question for the maker of the motion. I am grateful. I think it involving these elected members, I think is a good thing generally, but I do have reservations and I'd like to ask the maker of the motion, why just 2 members of the local governing board? And there's one more. So I just had that question, like, why 2? How do we select those 2? And then the other question was, what about that overriding concern that this is an allegation about someone who, I don't use the word innocent, but they may not have done anything wrong. And even if the name is redacted, even if we take steps to protect that identity, given the size of most LEAs, you could identify that individual. What happens to their right to write that presumption of innocence and not have their name sullied? Those 2 questions, if you'd be willing to answer or not.
Well, I did the 2 because that's what was in the rule. I mean, I didn't change that part. So I guess the question would be why 2? And then the follow-up on the what about, well, I guess my concern is every complaint starts with the presumption of innocence. So how do you investigate any complaint without it going somewhere? So I mean, what you're saying is if someone's innocent and they've been complained about, and it can't go anywhere, but you can't investigate something without it going somewhere. So
no, and then yeah, board member Lear, but let me just say that my concern is that, when we look at, I'm just trying to think through the process. And again, I value the involvement of the local school board. And I think as a state school board, we should try to do that more often. But these communities are small. What did Mark Twain say? A lie can make its way halfway around the world before the truth gets its shoes on. And these people have to live under that cloud, that the weight of this allegation. So that's all. And then if you could answer the question about why 2, and then board member Lear.
Yes, why 2? It's mostly from a practical standpoint, it can be extremely difficult to track down contact information for all board members. And then there's the question of if it is accurate, and we've had many cases where it's either hard to find or it's inaccurate. And because of that, we thought, well, it's better to have 2 than 1 just in case it's inaccurate or the information is not updated, just because there's not a standard for us to have that information. The USB does not have all governing board members of all LEAs. We don't. If anyone wants that motion, I would support that. Not that it matters. But really, it's just that practical standpoint. We think just in case there's an error, just in case it's not going to get to a board member, we do 2 just as a safeguard that 2 have it. Could we send it to all? Yes, it's just a matter then of the time it takes to track down all members of every board. And again, then it's like, well, then I'm telling more people how many people need or want to know. So
I was just curious about why 2. Board member Lear, to this particular motion.
in a small community, and this is my experience with the LEA I was talking about at the beginning. The person was accused of, because a family did not like the way that a coach and an administrator was addressing their children's needs. They said all kinds of terrible things. Again, slander on its face, I believe, defamation on its face about this individual, and it went to board members. And this person that was defamed before the investigation took place became a pariah in the community, and it happened. And I just don't think that's fair when it's only an allegation with no merit. And two board members, I think board members have a different, and I hope nobody takes umbrage at this, but board members, I think, have a different sense of ethical confidentiality than sometimes the trained executive.
Vice Chair Hart.
Yeah, and I'm not trying to be cavalier, but when you work in public education, you pretty much expect to be slandered on a regular basis. And that is, that sounds horrible, but how can you, it has to do with other people's children. It has to do with bringing to light things that in many cases are unfounded, but in other cases are unfortunately true. At what you're talking about is a level of professionalism for something that we can't legislate trust and good judgment, but we do have to make sure that we have processes that allow for the safety of children. And at the end of the day, these complaints, no matter how wrong some of them may be or far-fetched, it's somebody's complaint, and it can't be. I don't understand how we can be here saying that somehow we have to protect against the unethical behavior of board members and superintendent. The bottom line is somebody has made a complaint and it needs to be investigated. Now, whether or not it hits social media and gets out into the public is not something that we should withhold investigation from the very people that were elected to ensure the safety of children. I think we're splitting hairs at this point.
I would just say, I can't deny some of that's true. I am taking more of a lawyer's perspective, having seen the damage this has done to individuals' lives. And yes, there's sometimes damage done to families' lives. And I'm just kind of trying to balance the two. So I've got about 10 more amendments. So let's just go forward with this. And if we're not going to work on it in a more concerted way, then I really feel like it's my duty to make these amendments in order to maintain due process for the whole situation, because I don't think I just think the rule does not embody that yet.
Let me just ask, and I'll pose this question to the committee. Well, that's a bad way to do it. Let me pose this to the maker of the motion. Would the better process to be to have the superintendent disclose that to members of the board versus USBE? And again, I'm asking because the familiarity you have with that process, and I would ask Vice Chair Hart the same thing. Isn't that the role of the superintendent instead of us mandating that?
I will only speak from personal experience, having received a complaint through a constituent. I went to the school board chair and was able to discuss it thoroughly, learn the truth of what happened, find out what the district is doing regarding that complaint. And so it provided a full circle that the school board member already was aware of the situation, knew what the superintendent was doing with it, and it allowed me to respond to my constituents saying, this is a local issue. I appreciate you reaching out to me. I'm going to allow the board member to respond to you, which she did. So seeing the full circle, I've seen this work. Has the complainant had their concern resolved? No, not yet, but the process is in place.
Then we have a motion on the table, and that motion is that the committee amend lines 158 to 162 as follows. When the IAD makes a referral to an LEA, the IAD shall send the referral to at least 2 members of the local governing board and the superintendent. B, the LEA may send the referral to other school and LEA employees as needed to further investigate the complaint. It seems like we had all our discussion before the motion. Anyone?
Just,
Okay.
I did say investigate or resolve. Is it better to remove? No, I just, as you've read it, I said further investigate or resolve the complaint. That was my full motion.
Quick question, just do we need to put at the superintendent or charter school director? Is that a given? Does that need to be clarified?
I don't know what's proper, but if I read superintendent, I understand it's also.
Okay.
Okay, all those in favor?
Aye.
All those against? Me. So, and that passes.
Well, then, wait a minute. I'd like to change my vote.
I thought this was that.
And I would also vote no.
Okay, so that roll call is those in favor are Vice Chair Hart and Board Member Wood. Those opposed, Board Member Lear and Board Member Carey. Is Board Member Hymas. Okay, that vote ends in a tie. Because it's a tie, that does not advance. We are willing to entertain another motion, or if this is just going to proceed on the tie basis, we can advance any motions, and I would suggest that we move on to another matter. And that's why Matt is paid the big bucks. So when he comes here, he can figure that out. So
Amen.
do we have to
Is that a
table this,
vote?
Ben, or we just move on to the next one? How does that work? Because I'm not saying we're moving it off the agenda. We're just moving forward.
You can move on and come back to it. I think if the committee wants to do that.
There might be some of my amendments that they would like. I don't know. I mean, some of it, there's just so much duplication in this rule that I also wanted to get rid of that. And kind of philosophical stuff that doesn't need to be said. So I don't know if we want to hear it or if we want to move on.
Yeah, please.
Pardon? Oh, it's me. Sorry.
So as much as I oppose sending this rule back for, I think that we are ultimately in the position of being forced to send it back. So even though I object strongly, I move that this rule get whatever the motion was before. Chair, what was that motion?
Wasn't in the majority.
I
'Cause it
wasn't
was
in the
tied.
majority. I'm making it. Well, okay, so hey, board members, whoever was on the prevailing side, I'll change my vote if you bring that motion back up.
Make the motion.
That's right. Okay, we are on the prevailing side. Okay. Can you make that motion? Can you make that motion up here?
That the committee postponed.
Oh, I move that the committee postpone discussion of the rule and direct staff to draft 3 of the rule. Ugh. Okay, no, never mind. I have a different motion. Can I make a different motion? Okay. I move that the committee postpone discussion of the rule.
Any discussion on that? If not, let's vote. All those in favor?
What's your intent Can I have I have a
Please.
question.
My
on 10.
intent is to have the same conversation when there's 5 people present. I don't want
is
to
it gonna-
direct staff to do anything to the rule because I think that we're going to get all kinds of, I think our staff is in the same position that they were before and not really understanding where to go. And we have to have that conversation so that they're not having to guess.
And I would just suggest, and I understand you've made a motion and I won't change that or try to amend it, but I would suggest that, at least speaking for myself and my displeasure and I think we could work with staff to be clearer and more helpful, because some of my changes are just duplication in philosophy.
Right. And so
And I'll go through those 10 amendments if you want.
by saying that we postpone it, but not give direction on what needs to be done, then the same process would apply and people would send their ideas to whomever, just the regular process. But I don't want to make the motion that those things are the things that need to be changed, because I don't necessarily believe that. So all I want is it to go back and that to follow the process that we normally follow, where people bring their concerns and drafts and things, and then they sort that out.
Thank you for responding. I get it. I understand.
I just didn't want to direct that.
And to be clear, then the committee is not offering the staff any direction, but individual board members certainly can
That's
interact
correct.
with staff.
That's correct.
So again, if there's no other comments, then the motion before the board is that the committee postpone discussion of the rule. All those in favor? Aye.
Aye. Aye,
That passes unanimously.
reluctantly.
Yeah, thank you.
It's called hummingbird. It would be so great. Hummingbird.
Thank you, Chief Audit Executive Davis. So let's move to a 3.6, which is R277-123, LEA Fiscal and Auditing Policies. This is an amendment. And Director Rasmussen.
So this is R277-113, not 123, just to be clear.
Thank you.
Part of the amendments to this rule were dependent on what the committee does with 123. There are a couple unrelated things that are part of this too, but I think that those are not urgent. So I think that I would probably see if the committee wants to postpone this discussion as well. Because part of the change to this rule is the determination of what is going to happen with the local hotline. So I think it would be prudent to possibly postpone this as well. We can just move on to the next if that would be preferable.
Do we need to take a vote on this?
I think you've essentially, I mean, it kind of plays in with 123. So you can take a quick vote or you can just move on either way.
Just move on. Okay. So just to summarize, for 3.6 R277-113, Director Rasmussen said that these particular amendments are contingent upon what this committee decides regarding R277-123. In light of that, I would like just to make a motion to postpone this. All those in favor? Aye. That any opposed? That passes unanimously. Then 3.7, R277-306, Educator Preparation Programs for School Psychologists, Audiologists, Speech Language Pathologists, Speak Language Technicians, Counselors, and School Social Workers, Amendment and Continuation. Director Rasmussen.
Thank you, Chair. So R277-306 is up for its 5-year review. We need the board to take action on this prior to mid-January, I believe. So we do need a committee action, hopefully today. And then board action in December, I think was what we had anticipated. So we do have a few amendments that are primarily technical in nature to propose to this rule. I can highlight those. We're just adding an oversight category on line 21. The recommendation is this be category 3, given how often programs are monitored. And then there are a few places throughout the rule, like you'll see on line 27, where there are now more recent standards that are in play. These standards have generally been adopted already by the board in R 277-333. We just want to update the rule so that it's consistent with that rule. You'll see that on line 33 as well. And I think there were a couple of things where we updated the section numbers. And then finally on line, I just saw it. There was one more, but that's essentially line 110, the updating on the counselors, the professional standards. I'm sorry, the reference where those were incorporated is R 277-330. That's what's being proposed as far as this rule. Happy to answer questions. We also have Dr. Height who can speak to these competencies as well.
Thank you. And we will take questions. I do have, and I spoke with Dr. Height about this. If we can, Dr. Height, do you mind answering? Just.
Do you have a question?
I do. So my question is just with line 48 and 49. We talk about the 48 as implementing varied models and strategies of consultation, collaboration, and communication. And usually in rules, we see references to parents and students. And I don't see that here. And I was just wondering why.
Malia Height, Executive Coordinator, Educator Licensing, and we believe that including families includes parents.
Okay.
Is that language that comes directly out of the, I think that might be someone much smarter than me might, but it rings a bell that that's language that is repeated out of the what is it called? The thing that we changed the year on. I think it's repeated from the
National
Association of Schools. I think, but that is in no way conclusive. But I know that when you have to evaluate counselors and psychologists, the frameworks that we use that terminology instead, because that group isn't specific only to schools. So in talking about students and parents, that's school-specific language. And when you're talking about professional standards for psychologists and counselors, sometimes does that make sense? That they would be working with individuals and families rather than
students and parents.
Rather than students and parents.
Yeah, it was just for clarification. And then, Dr. Height, we had a good conversation on this, and I just want to make sure that that those listening or will listen understand. But we talked about guiding principle I-3, fairness, equity, and justice. And I asked if any of these provisions on these psychologists should really number their page. Oh, there it is, page 44 of the professional standards of the National Association of School Psychologists, fairness, equity, and justice. I asked you, does any of this language as it is here conflict with state law or board rule?
Yeah, thank you so much for the question. And I appreciate that we got the question ahead of time. We were able to consult with our ultimate experts. And so I consulted with both with Director Chalice on our student privacy and Dr. Voorhees regarding the school psychologist, and she is a school psychologist, as well as AAG Michelle Buse. And this section specifically is compliant with state laws regarding any of this language.
Thank you. And then we also had the opportunity to speak about and I cannot find it. So maybe if you could direct me to the page about the parental notification requirements of when parents can be notified and when perhaps they may not be notified. Do you have a page number for that, Dr. Height?
I do. It is on page 42. It's standard I.1.1, when consent is and is not required, as well as the following section, I.1.2, consent to establish a school psychologist-client relationship. And there are two instances within this section that ethically a school psychologist is allowed to function within their scope of practice without prior parental consent. The first is if they are working in the scope of typical classroom interventions, and that is absolutely compliant with our state laws regarding parental consent. It means that a school psychologist could come in and within a typical classroom, perhaps observe the classroom and provide the teacher with support of how to maybe best manage the classroom and some sort of behavior interventions or other things that any other type of educational professional might do, a school counselor or another teacher or an instructional coach, and that specific parental consent is not required in that instance.
And Dr. Height, if I may, in that scenario, the counselor is not speaking directly to the student. Is that correct?
Correct.
And
in that instance, they would be observing the classroom generally.
And any feedback would be given by the psychologist to the teacher, not directly to the student.
Correct.
And you said there was a second example where parental notification was not required. Could you share that with the committee?
Yes, the second instance is in standard I.1.2, specifically A, it is ethically permissible to provide psychological assistance without parental notice or consent in emergency situations. And so that is exactly parallel to our state law regarding parental consent. There is also a parallel provision in our ethical standards for educators in our 277-217 that requires educators to notify parents if some sort of situation, as mentioned in these standards, occurs within a school setting.
So if I understand correctly, there's an emergency, parental consent is not required, but following that emergency, our law does require notification of the parents.
Correct. And typically that happens at the same time, and administrators contacting the parent while the school psychologist is working with the student.
And then just one last question for myself, and that is, after you read this and spoke to our council, is there any provision of the when consent is or is not required provision that conflicts with state law or board rule?
No.
Okay, thank you. Any other questions from the committee?
I'd gladly make a motion.
Okay.
I move that the committee continue and approve our 277-306 educator preparation programs for school psychologists, audiologists, speech language pathologists, speech language technicians, counselors, and school social workers, draft 1 on first reading and forward to the board for continuation and approval on second and final reading.
The motion before the committee is that the committee continue and approve R277-306 educator preparation programs for school psychologists, audiologists, speech language pathologists, speech language technicians, counselors, and social workers, draft 1 on first reading and forward to the board for continuation and approval on second and final reading. All those in favor? Aye. Any opposed? Okay, that motion passes unanimously. Thank you, Dr. Height. The next item is 3.8, R277-419, pupil accounting. This is an amendment. Director Rasmussen.
Thank you, Chair. This rule covers a lot of territory. It's been brought up at the request of staff to make a request for to reinstate some language partially that was taken out of the rule about a year or two ago. I'm just scrolling down trying to find it. This is a very big rule, but here we go. So lines 267 to 273 are to 277 or where you want to look. Essentially, about a year or two ago, there used to be language in the rule that allowed an LEA to take 12 days at the beginning and end of the school year for kindergarten assessments, and it provided the detail on how that could be done. The board repealed that provision of the rule, and the staff has received a lot of feedback that it would be appropriate to have some of those days put back in the rule for kindergarten assessment at the start. The proposal is not to do the whole 12, but to allow up to 5 days at the beginning of the school year for assessment of kindergarten students. The other language that's been put in there is the exact language that used to be in the rule before, just that it has to be approved by the LEA's board, with notice to parents in an open meeting, and the time they take for assessment has to be adequate to justify the forfeited instruction time. So that is the proposal. The other change that's recommended is just a note. We haven't added an oversight category for 419 yet. So line 24, the recommendation is this be a category 4. This involves the WPU and a lot of things that are heavily monitored. And so this would be, the recommendation is to make this a category 4 rule. And we have Christina Elegante online who can answer questions about the kindergarten time. And happy to answer any other questions you may have. I know we may have one other motion as well.
Board Member Lear.
I really applaud this change to the change. I've heard from a lot of kindergarten teachers, elementary personnel generally, and I think that this is, it both goes back to local control and it also reflects what seemed like a really good practice to me that then was removed. So I'm glad we're going back to this.
I just have one other question. Do you have a question? Oh, you just right. My question is, why was this eliminated the first go around? Oh. Christine, do you have that? Can you answer that? Why was the?
Yeah, I was just waiting for Ben to pipe in, but Christine Elegante, K3 Literacy Specialist. I was just going to say, so when there was the change in the code that said 180 days that kindergarten students would be expected to attend the same on an equivalent schedule, as staff, we maybe overinterpreted that, thought that maybe that meant that we should try to make sure that they were going the same amount of days, so they'd start the same day that all the other students did. So we gathered feedback, not from teachers, more from LEA leaders, those who are over kindergarten programs. And we didn't really have a lot of strong feeling one way or other from those stakeholders. So when we came to the board last year, we had a couple options. One option was to do what we're doing now, and the other option was to eliminate all of the days. And the board voted to go with that option.
Thank you. Any other questions or comments?
Good. You can. We wouldn't be having this problem if we had numbers. If we went to 990 instead of 180. Just saying, this is. I think we need to look at our rule in general about seat time. I think this is a symptom of a larger problem. Having said that, that's a lot of instructional time, but yes, you can't give good instruction if you don't have good data about where students need to go. I don't know if it needs 5 days. I also know that parents have a little bit of trouble with this because it's transportation related. And I always appreciate things being left up to LEAs. So in general, this is a good idea. We're just going to keep getting issues about time and seat time and instructional time. And I really think that, between 4-day school weeks and graduation requirements and credit requirements and kindergarten. And I just think we need to spend a little bit more time on this issue as a larger issue. Having said that, I'm appreciative that it's not 12. I think 5 is a bit much, but no kindergarten teacher should have more than, I guess, I do have a question. This is not just a monologue. Christine, how long does it take to administer the kindergarten assessment?
Well, last year the board voted, we did change the assessment, the required assessment. It's a cadence now. So this assessment, this is the one-on-one parent meetings that have been held previously. The KEEP was done during that time, as the state has, this KEEP is still offered. But with that said, many LEAs are administering their own type of an assessment. Maybe some are still doing the KEEP, but what they're doing in those meetings, I think when I reached out to kindergarten teachers and I had conversations about this, they said they were having 20 to 30 minute meetings. That's kind of what they were looking for, 20 to 30 minutes per student to meet with the student, and then also with the student's parent.
So how many students then in a classroom? Do you know for kindergarten what the average is? I mean, I realize that's an impossible task, but in general.
Sorry. That is a loaded question. I've been in kindergarten classrooms that have had 15 kids. I've been into one recently that had 30.
We've got a second issue that we have to talk about, but okay, thank you very much.
Board Member Lear.
30. I had 2 questions. First, you know more about this than I do, Molly. I've just heard about this, but would it be worth, is 3 a better number? I mean,
No, especially not if people are shoving 30 kindergarten kids in a class.
Yeah, well, that's true too. And my second point was, I absolutely agree. We should revisit the 180, 990 rule, but let's do it with all stakeholders. Let's just not surprise stakeholders with a rule that says that. Let's get some people together and meet it a couple of times, because I know some LEAs, as much as that sounds like it would please LEAs, I know that it's unsettling for a lot of LEAs. So I absolutely applaud revisiting that. I just want to do it with those folks in the field from various positions.
And yes, I was looking for the amount of time that the new assessment, meaning the Acadians. Do you have some of that?
Okay.
Yes.
Oh, hi, Christine. I'll go ahead and answer that. Julie Clark, Literacy and Early Learning Coordinator for the Utah State Board of Education. So the exact times for the Acadians assessment for kindergarten at beginning of the year, it is 2 1-minute assessments. So about with including instruction time for giving instructions to the student, it's about 4 minutes for the beginning of the year. Middle of the year, there are 4 1-minute assessments. And so with instruction time, it'd probably be about 6 to 7 minutes. And then at the end of the year, there are 3 1-minute assessments. And so again, probably about 5 minutes. And those are one-on-one with the student. So.
And then so the total testing time also includes, they're doing a parent meeting, and then they're also must be doing a some sort of readiness.
Yes, so a lot of LEAs like to do a more in-depth assessment with their kindergarten students, just because they don't know them. They don't know what they're getting. They don't know what they can and can't do. And so prior to it used to be the KEEP. Prior to KEEP, they were doing other assessments. And so now they've kind of gone back to, some of them are still using the KEEP to identify those additional learning gaps or learning skills that the students know or don't know. And some are going back to some of the other assessments that they had, or they've adapted the KEEP to fit their needs better.
Okay.
So.
Okay.
Other questions? We're ready for a motion.
I do have a motion. This is kind of unrelated to the kindergarten issue, but because the code was open and has not been open since changes in our laws. This is in regards to adding line 76 in what a homeschool student is. And it would be IV or 4 instruction is, so homeschooling is not instruction when instruction is received by a home-based scholarship student consistent with section 53F-6-401.
And so I put that on the screen so you can see where it would go. The committee can see where it would go. It would just go right after line 76. So it would be a fourth, basically a fourth piece on the homeschool definition. Mm-hmm.
I guess I have a question for clarification. I thought under the UFA student recipients who were traditionally called homeschoolers, there was a new designation for them in the law because they wanted to make sure that there was a distinction between homeschool students and those formerly known as homeschool students who received the funding. And so if I read this correctly, then, oh, I see homeschool does not include public
Correct.
school instruction provided in a home, including when instruction is. I understand. Thank you for being patient. Okay, any comment on that motion? If not, we're ready for a vote. All those in favor? Aye. Any opposed? Okay, that motion carries unanimously. And then we are ready for another motion on the rule itself.
I can do that. I move that the committee approve R277419 Public Accounting Draft 1 is amended on first reading and forward to the board for approval on second and final reading.
The motion before the committee is that the committee approve R277-419 Pupil Accounting Draft 1 as amended on first reading and forward to the board for approval on second and final reading. All those in favor? Any opposed? That motion passes unanimously. Okay. Malia, do you see Dr. Hart out there?
Oh, sure, that was fun.
Okay.
Take a seat.
Are you speaking? Are you up next?
Oh,
Oh, yeah. Is Director Nui online? Can she hear us?
I can hear you.
Oh, hey, Director Nui, question on item 3.15 and 3.16. Are those time sensitive?
3.15 and 3.16.
Yes, R277-722 and R277-702.
Oh, no, those are not time sensitive.
Okay.
That's fine.
Okay. I just wanted to make sure if we didn't have time to get through everything, we got through those that we had to. So thank you for that. All that means is you have more time to wait. Okay, let's go to item 3.9, Board Policy 2006, Audit Committee and Chief Audit Executive Responsibilities. This is an amendment, and we have Director Rasmussen, if you want to cue that up.
Thank you, Chair. So this is coming from the Audit Committee. The recommended change is, let's see, I just passed it, starts on line 23. And it talks about review of draft audit reports. So you can see that the first change is on 23 through 31 there. And then there's one more substantive change that's further down on line 65 through 68 and all. And if it's okay, we can invite Chief Audit Executive Davis to explain the reason for these changes.
Please.
Thank you. So Debbie Davis, Chief Audit Executive for the board. So these changes come from House Bill 244 that was passed, which are changes to legislative audit reports and how we respond and how we have to follow up to our response. So a corrective action status follow-up. We thought it was important with the passage of that bill to outline roles and responsibilities. And in particular with those reports, they kind of extremely limit the number of available draft reports that are available before they actually release the reports to the public. And so in requiring essentially the language here to require either the chair or vice chair of the audit committee and then my role to receive a copy of that draft audit report, it helps provide leverage as we go to the legislative auditor general's office and say, we need this many number of audit reports, which again, it's extremely limited. In some cases, it's 4. They generally don't go beyond 7. And so having this and requiring transparency so that a board member would be able to see the report, and then myself as I facilitate that external audit process, we thought it important to codify that. So that's what's happening in the rule. And then the next agenda item is related to bylaws and it's looking at the role of the superintendents in the process as well. But that's what's prompting the changes here is just ensuring roles and responsibilities are understood and making sure there's transparency to the board to the extent possible, which is again about 1 draft copy of a report for the audit committee chair or vice chair to be able to see those reports before they're presented to the legislature with our response.
Thank you. Any questions from the committee? I have one question. This would be on lines 29 through 31. And it says after the board or auditing entity releases an audit report to the public, board leadership will assign. I don't know if that should be a shall, but that's technical. The audit to a standing committee for further consideration. Could you explain why we have that delay? Meaning, the audit committee sees it, board leadership sees it. The rest of the board is not privy until it's released to the public.
Okay. Yes. So the process is with an audit. Of course, everything regarding an audit that's in process. So under grandma, those records are protected, which is why they're limited. The legislative auditor's office, like we said, extreme limitations on reports before they become public. Similarly with our internal audit reports, it's limited to, I mean, the audit committee is getting updates and things. And then once they have seen pursuant to R277116, the report and made a recommendation, that's when it goes to our full board as a protected document, but in your executive, essentially confidential materials, you receive that. And then the board votes to release an internal audit report, and then it's available publicly. And then there's kind of a similar process with the state auditor's office. Their reports are protected. They give us a little bit more discretion about who can see the report before it's publicly released, but they still expect prudence and limitations, kind of who needs to see this report to respond before it's public. So the provision in 29 through 31 is similar to what happens in the legislative audit subcommittee meeting, where that committee essentially receives the report and it is public, and they hear a presentation from their auditors and from the audit client who responds. And then that committee will assign those audit reports to other committees of the legislature to consider and see if any lawmaking, rulemaking, policymaking is required. But just for transparency to the larger legislative body, they assign those reports to different committees. So that's kind of what the intent was here. Sure, the board gets those reports. It's all kind of, because until it's released, it's protected. How can there be a public conversation about the report and additional transparency for the board and the public based on those reports? So that's the intent of those lines, is to get it there as quickly as possible, but also provide a forum. When can the public conversation take place? And so the thought is, yes, assign it to a standing committee. It could happen there. Are there other ways it could happen? Absolutely. But that's what's proposed in this amendment.
No, and that makes perfect sense. And would you accept it as a technical amendment to change line 30 from will to shall? Without objection from the committee.
We've used will throughout the rule. I can go through and change that. We don't have the same guidebook that says what you have to do in a board policy that we do in a rule, but if I can go through and change that throughout, if that's what you want me to do.
If it's just to find and replace, Ben, that's great. Thank you. Any other questions, comments from the committee? Seeing none, we'll entertain a motion. Oh.
I move that the committee approve Board Policy 2006, Audit Committee and Chief Audit Executive Responsibilities, Draft 1, and forward the recommendation to the board.
The motion before the committee is that the committee approve Board Policy 2006, Audit Committee and Chief Audit Executive Responsibilities, Draft 1, and forward the recommendation to the board. All those in favor? Aye. Any opposed? That motion passes unanimously. Thank you, Chief Audit Executive Davis. And this related action item 3.10, Board Bylaws, Article 9 Amendment. And Director Rasmussen, can you cue that up for the committee?
Yeah, so this comes from the same reason. I believe it's HB 244. The intent here is to have in board bylaws specifics as to who is the presumed chief officer for providing audit responses. So you'll see that for USBE on subsection E, what you've got on your screen, that will normally be the state superintendent. The board leadership can designate someone else if needed. And then for USDB down in 2D, that will normally be the USDB superintendent. But again, board leadership can also designate someone else if the circumstances warrant. Are there any questions on this proposed change?
Vice Chair.
Can I just would like to offer a little context on this, why this is more of an issue. First of all, there needs to be more clarity in this whole space, but also that bill, that those particular actions by the legislature changed the nature of legislative audits, where previously in an audit, you were provided an issue, and each issue had a level of risk. And we could then take that report and make decisions about what we wanted to do, whether we wanted to accept that level of risk, whether we wanted to mitigate that risk. There were some changes where that decision making was preserved by legislative audit, where they can disagree with our accepting or not accepting of the risk. And so they can send it back and say, no, we think it's a higher risk, which in essence says, no, you must do something about this. And so because that is now, that decision making is more, rests more with legislative audit than our own agency, it's important that we are very clear and we're involved early so that we can be aware at a policy-making level, so that we're not putting our staff in a position where they know what's coming and they then need to explain to us rather than to the board about what needs to happen policy-wise. We are at the table right from the very beginning. It's just, it just raises the awareness that we and the level of involvement that we need to have from the very beginning of these types of audits. I don't know if that provides some clarity, but it shifted kind of how we are able to handle audits that come to us from other agencies. I don't know if that's helpful or not. Let me give you an example. An example is OLAG made some recommendations about our vision and mission in a previous audit. That vision and mission is a little bit harder. That rests with us rather than the superintendent. So as the superintendent and staff are trying to answer that, they end up having to be the mediator there. And that really needed to have us at that table so that we could, so that was clear and we didn't require a third party there where it gets a little bit more confusing. I don't know if there would be anything that you could add to that, or.
I guess the only other thing I would say is, and I thought you explained it very well, and the reason it says dependent on the audit scope, objectives, or findings and recommendations, we're never 100% sure what an audit report is going to look like until we get the audit report. We might know up front when they're explaining to us, hey, this is what we're going to audit. And you think, okay, that's clearly, we know the state superintendent would be the chief officer and it would be there. But in these other cases with like the governance audit or different things, we didn't know until we actually got the findings like, oh, this is actually a board level finding that the board should be responsible for. So it kind of preserves some flexibility as to, oh, who is responsible and who might need to respond. So it could be at the beginning, it might be at the end, but there's flexibility if there needs to be designation. But as Chair Hart said, it's important to have that flexibility and make sure that there is someone at the board level that's involved kind of throughout the process, in case, just because we don't know what's going to come up, but just that continuity through the process is very important.
And the response that's due today, the audit response that's due today to a state agency, when did we get the copy that we had to respond to?
Wednesday.
So due today, got the copy Wednesday. If we didn't have a member, which was me, then board would have no idea and a response would be due. So there's just some changes. with the auditing agencies that we work with that necessitate having some flexibility and some board involvement that we didn't have to have in the previous times.
No, that was great information. Thank you. Any other questions from the committee? If not, we'll entertain a motion.
I move that the committee approve board bylaws Article 9, Draft 1, and forward to the board for approval.
The motion before the committee is that the committee approve board bylaws Article 9, Draft 1, and forward to the board for approval. All those in favor? Aye. Any opposed? That motion passes unanimously. Sure. If no objection from the committee, we'll move to item 3.12. And that is R277-608, prohibition of corporal punishment in Utah's public schools by amendment. And it's my understanding that Deputy Superintendent Nui, you'll be queuing up this discussion for the committee.
Absolutely. Thank you so much for having me. Can you all hear me okay?
Yes.
Okay. All right. Well, we have before us R277-608. This is what is currently known as the prohibition of corporal punishment in Utah's public schools. This process started back in May or April when we were looking at all of the changes that needed to be made as a result of legislation passed in 2024. And there were some slight changes that needed to be made to both 608 and 609, which we'll bring to you in just a moment. But there was also concerns about these rules that were larger than these changes about the formatting and the content, and just being really confusing oftentimes for members of the field. And so we use this as an opportunity to overhaul both of these rules. So when you look at 608, and draft 1 is the draft that staff is proposing today, and that draft has a lot of new language, but I will note that most of this new language actually was formerly in 609. So 609 currently has all of the emergency safety intervention material in it. However, that was one of the areas of confusion for the field. And so we decided that it might be helpful to move that information to 608, where it can have a little bit more space and a little bit more of its own focus. And so a lot of the information that is in this draft 1 of 608 is just moved over from 609, if that makes sense. A couple other changes. Oh, sorry. A couple other things I wanted to bring to your attention is the oversight category, and this has been an ongoing conversation, but it is currently, staff is recommending that it is a 2, just because there is not regular monitoring in place, and that we have staff who oversee this, but as one small part of other jobs that they do, and so they are not fully dedicated to this. And so we felt that that was a 2, but leave that to the board to talk about that if you would like to. And then I think that's as far as I'll go right now. I'm sure you have questions, and we also have our amazing staff here if you'd like to bring them up and have them answer questions as well.
Thank you, Deputy Superintendent Nui. We are, any questions, comments? Board Member Wood.
Well, having looked at the significant feedback we got this morning at like 4 o'clock in the morning, I noticed it as my husband was driving down today. I would move that we would move this to next month if the body felt that was appropriate, just to be able to actually consume all of the extra data that we've gotten.
I would support that motion, but I would ask Deputy Superintendent Nui, in light of the fact that additional information was provided to this committee, is there any pressing reason or deadline associated with Board Member Wood? I'm going to say 3.12, 3.13, and 3.14, that they be postponed. Is there any pressing reason why we need to move forward with those today?
If you don't mind, Vice Chair, I would like to take that question to our staff that are present and see if they have any commentary. I don't know of any, but I would like to give them a chance to weigh in.
Hello, Ashley Lauer. I am a behavior specialist with the student services team. And there are other specialists and coordinators who are involved in these 3 agenda items. But we do feel like in light of the feedback that was provided, that would be okay to postpone if that is what the committee decides to do.
Okay. Any comment, or we are ready for a motion?
Can I follow up one
Oh,
thing?
please.
Yeah, one of the things that as I was reading it, I felt like this was a really great place to look at. Representative Ward phoned me a couple weeks ago wondering about his rule or law that passed HB 347. And I feel like this is a really great place, probably 609, to incorporate that. But I have also received feedback that staff has been doing some field work to get their input on how to properly implement that rule, and they will be done before the December meeting. So another reason to support my motion.
Vice Chair Hart?
I support all of that. There's so much going on in the space right now, and it'd be extremely valuable to be able to kind of condense it and consider it. I also had a separate question, though, if that would be okay.
Please.
When is a chemical restraint appropriate in a school setting? Do we actually do chemical restraints in schools?
That is a great question. So again, Ashley Lauer, behavior specialist. And it is something that was in 609 previously. It is not something that we are aware that is happening within the schools, but it's language that had been taken from the previous rule and put in this rule.
Okay. I would be interested in whether or not that does need to be in 609, either one of them moving forward. I just have some concerns in that space. I feel that we do de-escalation training, we do physical restraint training. The idea of chemical restraint is something that I just have a lot of feelings about.
And there is a prohibition, except for in a certain circumstance where there would be a medical professional who would be involved in that conversation. So,
and
likely it wouldn't be something that would be happening.
It would be part of an IEP, or I mean, we already pushed those boundaries, I feel, in many ways with catheters and other treatments that are somewhat body invasive. And I fully understand the need for providing services for all students. I think we need a second look at that. Thank you.
Thank you.
Sorry.
Any other questions, comments regarding this motion? Or not motion, but this item?
Yes, I do. I thought I read chemical restraint, and I don't know if this was accurate, to be like more of a medical restraint. To be more of a medical restraint. Is that accurate?
It is based on medical, and most likely that would happen in a different type of facility, like a residential treatment center, a higher level of care in that way.
But I assumed, maybe wrongly, that sometimes an IEP might call for some kind of a medication if a student's completely out of control, or am I wrong about that? It would never, or it might, or rarely.
I don't know that I have enough information in that specific realm to answer that question directly, but I can get you the answer to that question.
Leah's raising her hand. No, not really. She's more, I'm just wanting to make sure that we don't limit or prohibit what an IEP would allow. So in looking at that, I hope that would be a concern. And then I actually had a very short exchange with I'm forgetting now, maybe it was with Leah or somebody else, and sorry, it's been a week, but about making sure that all of this is always consistent with IDEA. That's a big concern of mine. And I've even worried about HB 347 in that regard. So that puts us in a difficult place if some of our special ed experts say it's not, but at least I want to know that our special ed experts say it is consistent. Any of these changes are consistent with IDEA.
Of course.
Okay.
Thank you.
Thank you.
Any other comments? If not, we are ready for a motion, and I would just ask that it incorporate 3.12, 3.13, and 3.14.
I made them. Oh, you made them. I'm sorry.
Oh, you made the motion?
The motion's been on. It's on the floor. Sorry, I didn't remember that either. Or I was misled by the chair.
We'll take the former.
Want me to repeat it?
Yeah.
All right, I will repeat my motion that the committee hold R277608, R27609, and R27609 incorporated document and direct staff to continue to incorporate feedback from the field and the Law and Licensing Committee and bring the new draft forward to the Law and Licensing December committee meeting.
The motion on the floor, and are we duplicating R2770609? Like, okay. Understood. Okay, thank you. So the motion on the floor is that the committee hold R277 608, R27609, and the R27609 incorporated document and direct staff to continue to incorporate feedback from the field and the Law and Licensing Committee and bring the new draft forward in the Law and Licensing December committee meeting. All those in favor? Aye. Any opposed? That motion passes unanimously. Deputy Superintendent Newey, thank you. Ms. Lauer, thank you very much. So let's go to agenda item 3.15, R277-722, procedures for the focused graduation pathway. This is a new item. Deputy Superintendent Newey.
Apologies. Okay, so R277-722 would be a brand new rule. This is the focused graduation pathway, and this creates a possibility for a student in unique circumstances with specific qualifications to enroll in a pathway that would allow them to take both the GRE and to stay enrolled in high school. And so this outlines what would be required of a school in order to provide this pathway and what would be required of a student in order for them to qualify. This is a new rule. And then just as a note, 702 is coming before you after this. And the changes to that is just to create an exception to our standing rules to include this new focused graduation pathway. I believe that we have Stephanie Patton here to answer specific questions about the program itself.
Any questions from the committee? Board Member Wood?
I sent the rule out to my districts that I incorporate my district and had some good feedback that I will incorporate a motion later, but I do have one question that I couldn't find in the rule, and maybe you can help me, is that there was a need to understand if that there are any policy recommendations for annual reporting requirements, non-compliance consequences, or any ongoing evaluation to help maintain accountability for this new program.
The intention would be that, and maybe it wasn't written into the rule, now I need to look back, but the intention was that if they were not meeting compliance, that we could kind of shut them out of, stop the program for that specific site. I think it's in there at the end.
It's line 105. And I just realized that that entire section should be underlined oh no, it is underlined. Okay. Apologies.
So, okay, so non-compliance with this rule, does this rule talk about any, that's where I was looking at in lines regarding the policy that the LEA has to put together, develop policies and procedures surrounding the FGP for their school. But in our direction of how that policy is created, there doesn't seem to be any requirements for evaluation. Or is that kind of assumed that they're going to put those in their policy? Do we need to direct that? Or I'm a fan of local control, but also a fan of accountability. Is there a way to balance that?
So are you asking that in the LEA's policy that they are making sure that they're evaluating on their end and not on our end? Oh, yeah, we don't have that in this.
Is that an appropriate request, or is our compliance sufficient?
I would push that back to what you feel. We would be overseeing it ourselves and making sure that it met the board rule but certainly we could include that.
So I guess I could ask the board, do you feel like there's sufficient local control in there that there's going to be, they'll maintain that accountability?
I'd be willing, Chair, to take a stab at that, answering that question with your.
Please, Vice Chair.
I think there's as much accountability as there is on any graduation program that we have. We allow them to determine when a credit is awarded and when graduation requirements are complete, then I feel like this could be. Now, whether that whole space might need reconsideration, perhaps, but I think this is in line with as much accountability as we do for other graduation.
I appreciate that. Then I have a motion unrelated to that question, if this would be an appropriate time.
I just have yes, it would be.
Okay. So one of the feedback from both of my Davis School District and Salt Lake School District was the staffing issue in terms of the requirement for a 15-to-1 ratio. I would think that if we had a 15-to-1 ratio in our classrooms, we probably wouldn't need any of these additional programs. So I would move that the committee amend R277-72233A as follows: maintain a student-teacher ratio not to exceed the average ratio of the participating school for all GED prep courses.
Any discussion to that motion? Board Member Lear, do you have a question? Yes. Oh, yeah. Is it Matt? Oh, you didn't sound like Matt. Matt, yes. Chair Hymas.
Yeah, I wondered if Leanne, first off, thank you. I wondered if Leanne could kind of expound on that. Are you saying 15 is an unfair advantage to this program? Are you saying you'd like to keep things? It sounds like you're saying you'd like to keep things average across throughout the school. Can you just expound on that motion a little bit?
Yes, so the feedback that I got was that 15-to-1 staff to student ratio could pose staffing challenges, particularly for schools already operating with limited resources. Districts may need to consider the financial and logistical impact of assigning dedicated staff to manage this program. And if we wanted to have a program be successful, I think we have to look at the needs of our individual districts and how they're managing the resources they have for their schools.
So thank you, first off, and I'm going to just interrupt and then I'm going to go on mute here, but thank you. This sounds like this is not a trying to be fairness thing. This is a trying to recognize resources motion. So I appreciate that. Thank you.
Thank you, Chair. Board Member Lear.
And I was assuming from the fact that that board member Wood made this amendment that you had checked, at least with the school districts that you work with, and they said this is doable. This is a manageable number for them.
To allow the average.
Yes,
Yeah.
to have it be the average. Because I do like having some kind of although it's not, it would be almost impossible to do that kind of monitoring or following up. I like the incentive of keeping it low. And I just have to go back for 1 second to the conversation about graduation credits and credits generally, and that is reinforced in case law for decades, that LEAs have the responsibility to give credits, take away credits, change credits, and determine graduation from those, except for the state sets the basic standard for graduation. So I would not want to interfere further than that. Just, I heard a hint of that might be possible, and I don't want to interfere further than how it is currently. I think that should be a Skyline diploma. Skyline High School, Granite School District should be able to determine what that should be. Okay, thanks.
Thank you. Any other further comments or questions as to the motion? If not, the motion before the body is that the committee amend R277-722-3, paren 3, paren A as follows. A, maintain a student-teacher ratio not to exceed the average ratio of the participating school for all GED prep courses. All those in favor? Aye.
Aye.
That motion passes unanimously. I would like to have us focus on lines 52 through 57. And I just want to know if these are necessary. Would it make more sense just to say an individual may utilize the focused graduation pathway if they, and then go right to line 59 through 72? Because we could add a whole bunch with, like, religion is not in that list. Like, there's just a lot of variables, so I don't understand why we need it.
Stephanie Patton, Adult Education Coordinator. We pulled that straight from the language that's in 702 R277 702, which you'll see is the amended one. That's where it came from.
Understood, but if we're saying these are the qualifications to be in this program, those are outlined in lines 59 through 72. Is that correct? Then I would just make a motion that we strike lines 53 through. Yes. And then we'll just pick up at 58. Vice Chair Hart.
I'm fine with that, except for disability. I can see that presenting challenges to a district, and them. I want to protect our students with disabilities. Like, I don't see anybody. It's fairly clear that race, ethnicity, that kind of thing. But when you get to disability, I could see some concern on how to make those kinds of accommodations or modifications. That one gives me pause. I don't know. I agree. I don't think we should have to state over and over equal opportunity, that. But
And I would,
if we could put somewhere in the lines below, regardless of disability status, or something.
And this isn't my rule, but I think if I can jump in, I think the disability laws are going to cover that. I don't think you necessarily need to call that out in the rule to protect individuals with disabilities. There are existing federal and state laws that would address that.
Just like the other ones.
Yeah.
Okay.
Okay.
It's as long as that's the case. I can just, it would require some creativity, I think, to make sure that accommodations are included for such a program. And I just want to make sure.
Yep.
Uh-oh, I opened a can of worms.
Please.
Assistant Superintendent Leah Voorhees, can I just add one piece of information to Ben's beautiful statement? So because we're talking about adult education here, students with disabilities are still eligible for FAPE until they age out, and then it would no longer apply. So as long as they're as long as they're trying to accomplish what you are being presented with up until age 22, then it applies. But once they turn 22, it doesn't apply, which can be problematic because adults have come back to us and said, hey, my IEP team said such and such, but now I'm over that 22 range, and so IDEA doesn't apply, so the IEP no longer applies either. So it's an important caveat. Does that make sense?
Yes.
Okay, thank you. Sorry.
No, don't be sorry. Thank you. Mike, let me ask a follow-up question. So if we include the disability language, which in light of your thoughts, I think we should, does that obligate the LEA to take individuals with a disability under our rule, regardless of age? Or do we have a provision that says this program is available to individuals in this age range? Does that make sense? Oh, but I'm being told it's only for juniors and seniors, but is there a scenario where you may have an older student be eligible for this program if we include disability here?
Excuse me.
Eligible anyways.
Yeah, so the other, like to
Regardless.
Ben's point, the other rules that you have already account for any disability related issue. So it's all taken care of. I just wanted to make sure that you understood that one of those rules includes that age limitation.
Understood.
But
So really,
your rules have already,
for purposes of
for
consistency,
purposes,
almost,
yes.
this should
Yes.
include disability.
Yeah.
Thank you.
Mhm.
And I
you.
would accept that as a,
So you want to, I'm not understanding either.
I thought you were agreeing.
oh,
You could do without it specifically
Oh.
because your other rules accomplish it. Sorry, I wasn't clear.
no, apparently you were, because everybody understood it but me. So thank you. Okay, so if any other discussion on the motion before the committee is that the committee amend R277-722 to strike lines 52 through 57. All in favor? Aye.
Aye.
Okay, that passes unanimously. And then let's go to item, thank you, Leanne. We're willing to entertain any more discussion or a motion on R277-722.
The motion.
Please.
I move that the committee approve R277-722 procedures for the focused graduation pathway draft 1 as amended on first reading and forward to the board for approval on second and final reading.
The motion before the committee is that the committee approve R277-722 procedures for the focused graduation pathway draft 1 as amended on first reading and forward to the board for approval on second and final reading. All those in favor?
Aye.
Yes.
That passes unanimously. And then our last item, 3.16, R277-702, procedures for the Utah High School Competition Diploma via amendment. And this is Deputy Superintendent Newey.
Okay. Hello again. Okay, so we have 702 before you as well, the procedures for Utah high school completion diploma. So this is the overall rule that governs high school completion. The only changes that you will see are lines 13 with an addition of the oversight category. And then down on line 53, we created the exception for the focused graduation pathway. So typically a candidate for a high school exit exam may not be enrolled in any Utah K-12 school. However, this new program that you've approved will create an exception to that rule. So
Thank you, Deputy Superintendent. Any questions or Board Member Lear?
No, I'm sorry. I was just. I'll ask it just so we know. My understanding was that districts sometimes used, and this path, I don't know, I'm trying to figure out how this pathway makes a difference, because my understanding was that LEAs sometimes used adult ed for graduation credits, or allowed students to use adult ed credits for graduation credits. And courses similarly. Is that a misunderstanding, or is that still accurate? And how does this affect that practice?
Stephanie Patton, Adult Education Coordinator. That is true in some, I don't think it's super widespread, but in some cases, school districts, students will withdraw from K-12, go to adult education, make up some credits, come back, and then those credits are used towards the graduation pathway, or towards the graduation in the school district. Yeah. This is different in that they're never leaving K-12. They're staying in K-12, taking the GED. GED credits, or GED is not currently used for credits, and that's not the case currently. And you can't take the GED unless you're withdrawn from K-12 currently. So it's allowing them to stay enrolled, use those for credits towards a high school graduation.
Okay, I think I understand I understand. As a just short follow-up to that, is this something that LEAs generally support also?
The LEAs that I've spoken to, yes.
Which would be 1, 5, 18?
Several. Yeah, we took it in front of alternative high school principals. There was general positivity towards it and excitement.
I'm not holding you to, did you talk to every single LEA?
I did not, yeah.
I'm just
several.
Hoping there's not a big objection to it in the field.
Yeah, and the feedback that I've received has been generally positive from LEAs.
Okay, that's helpful. Thank you.
Can I comment to that? I just want to comment to that because I was one who kind of voted tentatively to bring it back to our committee, and because I had heard some kind of negativity from it from a couple of my districts. Coming back and sending the actual rule to them, both came back and said, this is another option. We're always looking, we value choice. This is another option. They liked the guardrails that had been put in place, and that it was an option for a specific school, so they could look at it very carefully. A lot of local control built into it. And also, I reached out to a charter school that I recently toured, and he came back so excited that this was, totally for one of his schools that it will work for. So I appreciate seeing it in black and white made such a difference rather than kind of this up in the air idea. So thank you for your work on it.
Thank you. I do have a motion. This is related to the one that we made in 722 for lines 45 through 49. And the motion would be to strike lines 45 through 49.
Hey, Joe, I'm sorry, I'm driving a manual car and it's on my phone. I can't read those. Can you give me a summary?
And it's uphill both ways.
I know.
Yes. Anything else you want to put? Yes. So it would be to strike lines 45, race, color, national origin, gender, disability. We are leaving in state of residency.
Okay, so same discussion as last rule, ultimately.
Yes.
Thank you.
Because I don't think there is a law or provision regarding that. If there is, I'd be happy to do it, but I wanted to err on the side of just making it clear. But if it's redundant, we can certainly add it to the, not that I'm aware of. Yes, please.
It's actually important if you have it in. It would change practice pretty significantly right now because it says that it's regardless of state of residency. We have others who come to Utah specifically to take the GED, and yeah.
That's another.
Please, Board Member Lear.
So does that mean Utah's subsidizing those students? Or is it just they come, it's literally a place to come, they make the payment, they go back to Wyoming, whatever?
Yes.
Okay.
Yeah, we're not expending funds on it, but
okay, thank you.
Okay, if there's no other comments or discussion on the motion, seeing none, the motion before the committee is that the committee strike lines 45 through 49 from draft 1. All those in favor? Aye.
Aye.
That motion passes unanimously. And we'll go back to the rule itself and the entertain a motion on that.
Go ahead. I move that the committee approve our 27772 procedures for the Utah High School Completion Diploma in Draft 1 as amended on first reading and forward to the board for approval on second and final reading.
All those in favor? Aye.
Aye.
Any opposed? Oh, sorry, Matt. Any opposed? No. That motion passes unanimously. Thank the committee, and Matt, we'll see you soon. Oh, we have one more?
Are we wanting to go back to item 3.11?
Do you hate us? What are you doing? Oh, no, we did skip. Thank you. You don't. I thought you were taking us back to the cat rule, the 9 lives rule. Is that okay? 11. So thank you for that. Yes. So item 3.11, personnel management audit report review. And I believe Debbie Davis will cue us up for that.
All right. So yes, Debbie Davis, Chief Audit Executive for the board. And this is, so the personnel management audit completed a couple of months ago and the board released it. And at the time it was released, the board requested or moved that this would be an audit that is assigned to a committee for further consideration. And if you recall, this has now been recommended by Law and Licensing to move to the board in Board Policy 2006, that this would kind of automatically now happen if the board approves that in 2006. So this is an opportunity for just transparency to the audit, to discuss what's there, consider what's the board's role when these audits come out. And again, Kevin, our deputy audit executive, Kevin John, was going to present, but he's presenting on technical assistance in standards and assessment. And the good news is I read pretty much everything in audit. I get to read it. So I'm happy to kind of kick off a presentation, but also very interested if you have questions, whether it's process or content or anything, please let's have that discussion at this point. And since this is kind of a kickoff, we're just starting to do these. If there's formats or ways to present this information or consider these audits, we'd appreciate any feedback you have on that. This audit, so personnel management, the audit really strives to look at what we call the control environment of the State Board of Education. And Internal controls, very important to us. Internal controls help us achieve our objectives. And there are 5 components of an internal control system, and the control environment is the first. It is the foundation, really the foundation of everything that you do, so that again you can achieve your objectives. So a few years ago, we did look at the internal control system, all 5 components, and so there's been work done there, and the audit recognizes that work has been done in that space, but also that there's still room for improvement. And again, because this audit is specific to the control environment, then that's what the focus is. And so we'll kind of dive in, and as we look at this, and just for context, and because we talked about baking earlier, let's talk about salsa for a second. When you're considering, okay, I have this audit report, how does this matter? What does it matter? What's the significance? Well, think about salsa has a lot of ingredients, and I will say Kevin runs a pretty good garden, and he makes his own salsa. It's good stuff. But right, you have garlic and peppers and tomatoes and all these things that are coming in, and they're part of this awesome salsa that gets made. Well, what if you accidentally add an additional cup of tomatoes to your salsa? Not the end of the world. Salsa's probably still going to taste pretty good. But what if you add an extra cup of salt or a few too many jalapenos, right? You could ruin your batch of salsa. So not all things that we find in audits are created equal, but they're findings nonetheless, right? It's like, oh, I didn't quite follow the recipe, this or that. Some are more significant than others. So kind of with that as a backdrop to this audit, and you can see on the screen, high level, and the audit report points out, it's a very long audit report. Well, the report's short, but there's a lot of appendices with a lot of data, because we think that provides information to management that they can take and then really look at to see what changes they might want to make. So the kind of the 5 areas that we looked at where, okay, high level, we think this summarizes the things that we saw. So first would be organizational structure, right? You set an objective, and I would say the board strategic plan helps identify the objective that the State Board of Education is striving to achieve. And so with that objective, you say, okay, we need an organization that's going to do that. What does that organization look like? So the first area kind of looks at that structure, and is it hierarchical, which is kind of our org chart and shows like, yeah, there's a hierarchy and people report up or down the line. But then we also note there are some projects and things that are happening where we call it a matrix, and it's like, oh, we're pulling people out of that hierarchical structure and they're helping on these other things. And is there appropriate accountability when that's happening? Or is that creating pressure within this system, again, for accountability, but performance? And does it come to the next item, which is, what are the expectations for personnel, and are they realistic? And in some cases, we're seeing that, hey, maybe there are some unrealistic expectations for staff. Let me run down. There's a couple of examples. And we're not going to roll up and down the whole report because we'll get seasick, but I can point a couple examples, but yes.
Yeah, so I just want to say, like, when I read the overview, I guess my question is like the purpose of an audit, because this seems highly subjective and even negative, and that hasn't been my experience on these items that we have here. And when I read this, it's almost is the purpose of an audit to point out the good and the areas for improvement? Because when I read this, and again, this is my takeaway, it seemed very one-sided. Is that when we audit, is should that be the focus? Like, should it be, hey, we got to identify the areas of improvement, or is there supposed to be but these are the things we're doing really well? And that, again, irrespective of this, I'm just asking the broader question, what is the purpose?
Before I answer, is there a comment? I don't know which to go for. Do you want me or Member Hart? Okay, I'll answer. Okay, yes. Happy to answer that question. Audits. So the reason you prioritize an audit, or that we do an audit, is because there's some kind of perceived risk, right? Something that is maybe getting in the way of us achieving our objective. And so the audit is intended to go in and say, is this really a barrier? Is this really a problem? And if it is, how significant is it? So if you look at the table of contents of this report, you'll see it's laid out performance, and it's, okay, we've identified some risks, then let's assess it and say, so what about these risks? Does it even matter? And then we have some risk response recommendations. And that's, if you look at the table of contents, it really lays out for both performance and compliance that's how it's laid out. We want to identify, assess, and then are there any recommendations? So it is geared to that, really just this risk process. Let's look at it and again, try and see, are there barriers to us achieving our objectives? In that process, it definitely comes out as, hey, let's look for areas where we can improve. Should we call out if positive things are happening? Yes, we want to do that, but we also have to balance that with, how long do you want the report to be? So that's a factor as well. So we're trying to balance all those things, but I would say everything we're doing with the report is intended to kind of coalesce around those risk identification, assessment, and response.
Yeah, and I appreciate that. I really do. And again, my concern when I see something like this is that it could be misinterpreted if that's not extremely clear, that the emphasis is on identifying, assessing, and addressing. So thank you, Vice Chair Hart.
Not the strong and the weak. And then what we decide about it is up to us. Like if audit goes into that, here are some great things and here are some not so great things, then it's not actually an audit, it's an evaluation. And maybe that's wrong, but it helps me read audits, what comes out of the auditor's office or OLAG or our audit team. It helps me read it for what it is. And the best, I think the best audit reports, when they're written, they actually don't give you that information. And often that ends up to be a criticism because we want, some of that we want to be guided and we want to know, is that good or is that bad? But the simple fact is, if they're telling you if it's good or bad, then it's not any longer an audit, it's an evaluation. So for me, it helped me use audits for what they are, which is data. And then it is up to us to wrestle with that and determine, how much risk it is and whether we're willing to take it. Audits only get us like 1/3 of the way to decision making. And we would prefer audits to get all the way because it minimizes the work we have to do. So that was something that took me a couple of years on the board to even become okay with it. And I feel like once it was that kind of decision, then the information became so much more valuable because it didn't have that judgment. We see the same thing in teacher evaluation. We're trying to give feedback and information, and teachers like, well, is it okay? Well, that's not the job we're trying to do right now. We're trying to give you information so you can make a professional decision. So I just think as we look at these audits, I think we have to be very, very careful how we interpret what the audit team should be telling us or shouldn't be telling us. And it kind of complicates it when maybe legislative audit or other auditors maybe are not seeing it as quite that way, but at least that's how I think our audit team has to. I don't want to ever put the audit team in a position where they need to make a judgment because I think that compromises them.
Thank you. Remember, Leah?
And I haven't read this recently, so I can't point out examples, but to your point, Vice Chair Hart, I felt like, because I think that's a two-way street in terms of interpreting audits and then information received from audits. And I felt when I read this initially, and again, I wish I could say I read it yesterday and I could point out examples, but I felt like this was, and that's why I put the words in Chair Vice Chair Carrie's mouth of, it felt more subjective to me. It felt, without examples to point to, and that concerned me some. And that, so I think it's really behooves both parties involved, both the staff doing the audit and the board and staff reviewing the audit, to just check their objectivity every single step of the way, because I felt like this was not the most objective report I've ever read, and that concerned me some. On the other hand, I have to use an example from many years ago when I was a hearing officer from appeals to audits for a child nutrition program. And I literally did probably 5 a month. So I did a lot of them. And one of the things I found helpful in those audits, that sometimes some of the auditors that then I would go back to, they would balk at, and someone would say, oh, never thought of that, is they would overclaim some child, and I'm going to use a real tedious example, but I think it illustrates my concern. They would overclaim a preschool that the board was in charge of at the time, for not serving the required amount of milk, and so they would completely overclaim the whole shoot and match, and have $100,000 that a preschool had to pay back, because the auditors didn't feel like it was their job to say, well, they were supposed to give 2/3 of a cup and they only gave a half a cup. And so I look for that information from audits so that we can more effectively decide where to go from here, and not just, nope, they didn't do this well. And so I'm being very general now, but rather they didn't do it well to this extent. So I think that's one of my messages to auditors, to say, and I don't believe that brings subjectivity into it. I only believe it brings more completeness into the discussion. And I wish I could point to examples, but I felt like a little of that was missing in this as well. Sorry for letting me get that down.
No, and if I could, I have an example I'd just like to go over in the report itself on page 77 under training and resources. And I read this and I wasn't sure, I actually went through 3 different thoughts on it, because I went through, this is a good thing, this is a bad thing, this is an awesome thing. And it's the same provision, but here it says, in 2024, there was a survey, 59% reported that management always encourages professional development. And I read that and thought, that's a good thing. Like, could it be higher? Sure. But to me, that was a significant finding. But then the next segment says, although interestingly, there are some who reported never or rarely being encouraged to obtain professional development. And then I thought, is that really significant? We don't even know. It just says there are some. And that leads me to think, was that the other 30%, 40%? But then I turn the page and I read the last paragraph, and it says, but 90% provided reasons why they participate in professional development. And so I read all those things and I'm like, well, wait a second, isn't the last one in some ways the most important? Because it certainly is indicative of an environment where the staff know that they have these opportunities available and that they're availing themselves to them. And so again, and this is just, I'm walking through the thought process I had, which was, I don't know how valuable this was to me, because that that segment of, although interestingly, there are some who reported never or rarely. And without knowing that number, I don't know what to do with that statement. Does that make sense? Is there a way to it? If you could just address that. Am I looking for too much? Like that just doesn't happen? And am I wrong to say, but at the end of the day, if 90% of staff, availed themselves to it, and I wish Director Rasmussen would, is that a bad thing? Like, is that, because I look at that, it ends on a happy note. Why did we go through that structural development to get to a place that I thought I was being led somewhere else? And again, that's me. I'm not speaking for the committee. That's just my question.
Right. Well, I think we all bring our background, our experience into when we read an audit report and we're kind of analyzing. If we say, here's the risk, what do you think about that? Well, I might think one thing, you would think something else, Director Rasmussen would think something else, right? So we're bringing that into the report. And our intent with internal audit, I have a pretty diverse internal audit staff, and I have all of my staff read every report to say, what do you think about this? What do you think about this? Do we include it or not? Because we have that discretion, right? We're putting the report together. So what should we include and what should we not? At the end of the day, we are trying to we want to be objective, and so we provide a lot of information. And so maybe that value judgment word of interestingly should be left out, and it's just like, here's the data, and we're just saying, here's all the data, and do we think this leads to a risk? Because there is, I think it's is it Appendix C, and it's just data, 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 data. And then it's, okay, how do we summarize that? And that's where we went back to the body of the report and we said, well, we think we can summarize this into kind of 5 areas where there's concern or there's risk, right? That maybe something should happen. And so we do go from, we want to provide every data point, and maybe it's as you look at it and it's like, okay, the survey said this, but then it said this, but then it said this. What am I supposed to do with that? Maybe it's in looking at every data point, I think this is low risk. I don't think there's anything we need to do, which is why in our risk response recommendations, every time we say, it is up to management and the board to really consider these risks and then evaluate. Are they low? Are they medium? High? What does need to be happening with that? We will suggest some recommendations, but ultimately it's up to management and the board as to will an action be taken. And this is exactly the process we do with the legislative audit reports. They'll say, this is our recommendation, and we'll say, well, we think that's low risk. We're not going to do anything. So that's part of the audit process, is to say, well, the auditor might have thought something, but maybe they don't have the whole picture, so we're not going to do anything. And then that decision, of course, could be evaluated as well. But I would say, yeah, there is definitely professional judgment in what goes into the report. There is quality assurance of many eyes on the report before it's published, and just a recognition of, in particular with this report, there were a lot of data points that we were looking at one point in time. We probably had over 1,000 pages that we were trying to summarize into the 150 that we provided to you. So I won't defend whether it's there or not. Do we have the number? Could we tell you what some is? Absolutely. We can track that back pretty quick and let you know. But yes, the report is what it is. And hopefully it provides enough context that if it's 10% or if we say 59% and then some, it's like, well, that could be up to the other 41.
Thank you. And I know that we interrupted your presentation. Are there a few areas that you feel you absolutely need to share with us in your report?
Roll down really quick on talking points. Kind of another analogy that we've used with audit reports is, and this is within the risk realm, is, well, what's our risk appetite? What's the risk tolerance? What's okay? This actually came up with the technical assistance audit, and it's like, well, what if 10% of the material on our website is not accurate? Is that okay? I don't know, is it? Well, so the analogy is, well, what if you're playing football? And what if, one person is not assignment sound? Well, if it's alignment, okay, what if they're not doing okay? But what if it's the quarterback? Is there a difference? Or maybe it goes back to our salsa, right? Like, are we talking tomatoes or salt? How far off can I be with that item before this really is a problem and it moves from low risk to moderate risk to high risk? I think overall my impression, and I mean, there's so many data points that we could dive into. And I will say this survey, we tried to come at personnel management from a lot of different points. So we surveyed, we interviewed, we looked at data and documentation. And so that's what we were trying to say. Once we look at all of that, what does the story tell us? And I think from the survey, and if you compare, I think it's from the 2018-19 survey to 2024, it looks like employees are feeling at least as happy about working here as they were in 2018-19, if not a little more. Like, yeah, we enjoy working here. But then as you look at data at some of our performance plans, if you look at policies and procedures where employees say, well, but it's really not clear. I'm just really not sure. Or, hey, the way we go about performance evaluation, of course I'm happy because I get to pick everything that I'm evaluated on. So why wouldn't I be happy? So I think there's some of that going on. And I think that's where those data points will be important to look at and not skew and say like, well, the survey says it's okay, so everything about personnel management is low risk. I don't think that's the case based on the entirety of the data that we looked at, the interviews that we did, right? I mean, I'll just give you one, since you'll be looking at your strategic plan, right? So in the supervisors that we interviewed, 66% couldn't effectively communicate their critical functions. If you don't know what your function is, if I don't know what I'm supposed to be working on and I can't communicate that to anyone, is that a problem? How does that align with the strategic plan? How do I know if what I'm doing is valuable? So those are some of the data points where it's like, okay, I might need to think about that for a moment.
And let me just say this to the committee. I think, Debbie, obviously, I think would all benefit more from a conversation. So if somebody has a question, please. Thank you, Board Member Wood.
So in the book, Crucial Conversations, they talk about facts don't have emotions. So it seems like this is a lot of facts, and that either you, the audit committee, or the board or management puts the emotion into it. Whose role do you think that is to determine? And then we'll put emotion or risk. I mean, we'll kind of line those together. But whose role is it to determine that in the end? And then what do you see our role here? Because one of the things that stood out to me critically was a need for supervisor training. That seemed to be like over and over. People just needed to know better. What are my roles and how do I do them? But I don't see that really as our role to dictate that to the agency. How do you see it all kind of fit together?
Sure, absolutely. I think for internal audit, I would say we are trying to be as unemotional as possible to provide that objective view. That's where even when we try and put our headers together, we're trying to say it's not like internal control system weaknesses. It's just like internal control system and consider this. So we are trying to pull judgmental value judgment language out of our reports. Are we perfect at it? I'm sure we're not, but that is our attempt. And really, right, maybe it's, and maybe I shouldn't say this, like an election, right? Like we all might have whoever we're supporting, but who needs to know what I'm supporting? I should just be telling you the facts, and then decisions can be made. And again, based on risk, if you can say, well, the auditor said this was the risk, I can say this is why it's not a risk, and that's management, and they're taking the action. That's fine. So maybe there could be a little bit more emotion. I guess, on the side of management. I don't know how much it needs to come into it at all, though. If our culture is such that we all want the best for public education, we are committed to improvement. And if that's the case and we can all work together, then yeah, hopefully that's the emotion driving us forward. And that's where the passion comes in, because we care so much. We care so much and we want to do better. So we're willing to listen to each other. We're willing to have conversations, even if they're hard. And even if we disagree, that's okay, because our culture is such that we can talk about that. Okay, I was going to go to your second question, but maybe while I rethink about what I was going to say on the second part.
I have an opinion on that. This goes to show how audits can have different audiences. In this particular audit, I don't necessarily think that it's a board. It's in the board's purview, except that we need to ask, in this case, our CEO or our other direct reports, what concerns you about this? And how can we support you in whatever? So in this case, this particular audit hands some data back to that's hopefully objective. It hands it back to our administration to say, here's what we found. Does this, is there anything that you want to do differently that we could help you with resources? Or is there something that we need to put resources towards further study? Like that's, personnel is not unless it uncovered something about our direct reports, it's not ours. But it is our responsibility to make sure that the people that do have that are reports that are responsible for personnel, we have to make sure they have the resources that they need. So while personnel isn't our direct responsibility, making sure that they have the resources that they need, say when major staff departs.
You mean the superintendent?
The superintendent and yes, she, in this case, yes. I'm just trying to be agnostic to whoever it is. But like, well, it could be, it could be her, but it also could be Debbie's staff, or it could be Scott's staff, or it could be something that Kelsey and
they're really all the superintendent's staff.
They are, but we still have responsibility to provide resources to the people for the areas that but yes, that's why I said CEO. So if they need resources, if she needs resources, or if Debbie says, half my staff didn't know, this started a conversation amongst our staff and we're not getting to our critical functions, then that's a conversation that needs to come to us for prioritization. And so sometimes audit can serve a function that isn't directly ours, but is indirectly ours, because we need to make sure that the policies and the resources are present so that they can be successful in their jobs. And our CEO can be successful in her job. When major high-ranking staff depart and there needs to be rearrangement, this is the data that would be used to make wise decisions. And it's just it's a resource. It's an audit. It's data.
And then, Debbie, I was, again, just because of the time, are there certain areas you would like to focus on, or you feel this is essential for this committee to know about this report? And then again, committee members, if you have a certain section that you want to ask specific, I'm sorry, Carol.
I did have one more comment.
Oh,
and
please.
I'll promise to make it short because it's kind of perseverating on this same issue. But I want to emphasize that I have come on a long journey to very much respect the audit staff, but I'm hoping that if this conversation is meaningful, we can give you feedback that I believe at least that would be improve your improve these reports going forward. To your point, and I really liked your comments about objectivity and how you have all staff members, but I do think everyone in their own sphere gets kind of caught into your own little self-fulfilling bubble. So I just wanted to point out, just because we were on it and this illustrates it so perfectly, you say you want objectivity. If you say that's what you strive for primarily, then we go back to page 77 and it says exactly the lines that Vice Chair Karen quoted. Although interestingly, you acknowledged, interestingly should probably go. There are some who reported, and I would absolutely say that some, it seems like one word and not a big deal. But if you tell me 2, it's a whole lot different than 25. So I feel like in the spirit of objectivity, you find those things and you say, wait, some suggest in a very sensitive area that there's more dissatisfaction than 2 because of the last paragraph in that same section. So just to give you an example of where I think sometimes the process misses the objectivity it strives for. Because I caught that too and saying, that's not good. But then it's a whole lot different to me if it's 2 and then given the last paragraph. So just wanted to point that out where I know we're all striving to do better, and it's not meant as criticism, but it's meant as I hope helpful insight about where you kind of missed what you're saying you want to be. Okay, thanks for letting me do that.
Thank you, Board Member Lear. Is there a section that you want to draw our attention to?
So there's a section on workload. It's in structure, and I'm sorry, I'm kind of going from notes because again, I wasn't sure how much scrolling we really wanted to do. So this is, I think, section 8. So 3 structure, H workload. And as we talk about workload,
is there a page number?
Let me get to it.
Because unlike you, we didn't memorize all the.
It's not memorized. Okay. So in the report itself, it starts page 82, workload, right? And again, this is a conglomeration of survey, interview, and then data and things that we looked at. And I think workload is really important because so much of staff is supporting the work of the board and how we report up to the legislature, right? Every year it seems like there's requests for FTEs and so what is needed. And so I think for the board, this is an area in consideration of what is staff workload? How is it perceived? What is it actually? And then this translates into, well, what there are employee benefits associated with this as far as, well, I have leave, I have annual leave and sick leave. I might have overtime or compensatory time. And can I take that time? Can I use it? Let's see, as I scroll down, there's various charts in there about why do I feel overwhelmed with my workload? Are there too many projects? And that could go back to organizational structure, perhaps. Or is it, there's certain times of year when things are really busy. But I wonder, just looking towards the end of the year, particularly for probably executive staff where we put in overtime, and does that mean we're going to take all of the month of December off? Or we're going to use or lose our leave. And should the board be aware of that you have staff that we can't take our leave. And so even though, if I felt like, I'm paid pretty well, but if I put in all this time and I can't use the associated leave that I get from it, then I'm really not getting paid as much as it says I am, right? Because I've essentially given you time that was not paid for. Should the board be aware of that? I think the board should be very aware of workload of staff, and that goes to, are there realistic expectations for employees and the work that we're doing? And if there's not, what needs to change? Does everything need to slow down because we can't continue this pace, right? And so it gets into a little bit, is there burnout? Is this impacting our turnover, which is extremely costly? There's a data point in there about from 2021 to 2023, even though our turnover looks like it's better than, or at least, on par with other state agencies, from 2021 to 2023, we lost 36%. Right? Like that was the turnover from kind of that cohort of that time. That's a lot. That's big. That's a lot of investment in a hiring process, in a training process, in what happens there. So probably if I was going to highlight something for the board, and I think, again, there are roles and responsibilities, and we've talked about, well, what should the superintendency take away from this would be different from the board. There could be things that the board could ask for, just like you get a monthly budget report. Do you get any monthly personnel reports? Do you get a monthly, this is how many staff have overtime? Do you get this is how many staff have their performance evaluations have been activated? Are there any that haven't? So is there data that the board could ask for that would help you understand the personnel of the agency better and help as you go to the legislature and try and advocate? Maybe there is some data that could be provided that would be very helpful for the board that you could take, and this workload section kind of gets into that a little bit. That's probably the top one that I would say, but happy to answer questions about any other sections or.
Board Member Wood.
Well, I have a comment just on one of the, I think page 84, where it says, the work ebbs and flows. Legislative session is always crazy. There's not really anything that can be done about that. Also, sometimes I get unexpected assignments, such as requests from board members that I haven't budgeted time for, and this can be difficult. I think that's important for us to know too, that we're add to the workload if we're not careful in how we, don't always go through the different hierarchical procedures. We bounce around and go to this, maybe our favorite one, we know we'll get it done. That's the person who's the busiest, right? Because we all know they'll get it done.
I do have one question, and I didn't see this in the report, and maybe it wasn't covered, but was there a section that talked about and let me just start with this because I made a note of this. It is clear that you and your staff are trusted, because I don't think I could answer some of these questions with the candor that the employees here did. And they did that because I believe that they felt it was, going to be anonymous, going to be preserved in private. But was there a section of this report that talked about the comfort level of employees speaking to their supervisors, speaking to their
Kevin John, Deputy Audit Executive of the Internal Audit Department, which is your department. So happy to be here. Sorry I was late. We were doing this same exercise down in Standards and Assessment. So yes.
They're much less efficient. So we were ready for you like 40 minutes ago.
Yeah, they did have 7 agenda items and you guys had what, 14, 16? So very impressive. No, it's a great question. It was one of the things that we asked on, and I don't know if Debbie's already shared it, but one of the data points that's in the report was that 8% of the respondents of the survey did not feel comfortable sharing information up their supervisory line. 8%. So 8%. So not a huge percent, but concerning nonetheless. I know if 8% of my staff didn't feel comfortable coming to talk to me, I'd want to know, or I'd want to rectify it at the very minimum. So there was a question about comfort of them moving up. As far as comfort with the survey itself, that's not something we specifically asked. I think you can maybe look at response rates, and that might help you understand whether or not they were comfortable with.
I was addressing the comfort level, the report up, and
okay,
that was
so perfect. All right.
Okay. Any other questions? And if not, no. Okay. Debbie, thank you very much for your time. Kevin, thank you for answering that one question. You hit a home run. Thank you. Ben, is there a specific action we need to take on that report? Okay. Then with that, did I miss something else? No? Okay. Then with that, we'll entertain a motion to adjourn. Okay. All those in favor? Aye. Thank you.